Hello my dear students, welcome back. Now we are in chapter number 7. I hope you have done with all 6 chapters nicely. I understand that chapter 2 and chapter 3 are little lengthy, but it's very important for you to learn chapter 2, chapter 3 correctly, because most of the cases are asked from those 2 chapters. Rest all the chapters you will get the direct questions. Okay, so only chapter 2 and chapter 3 are tricky. So let's start with chapter number 7. Chapter number 7 will be learning something different. Okay, we are going to learn about non-profit organizations. Till now we have seen all the business organizations, but in chapter 7 we are going to learn about various non-profit organizations in India. So if anybody's main intention is not doing business or not doing profits, okay, they want to do something for the society, like they want to educate the children, those who are in need, those who don't have money, they want to do empowerment of women, they really love our heritage, our environment, they want to do something for them. Some of them love pets, they love animals, so taking care of animals. So for all these kinds of institutions, they can form an organization whose main intention will not be earning profits. Now what kind of organizations are there? In India, if we want to form a non-profit organization, we have 3 options. First one is Section 8 company, which is registered under Companies Act 2013. Second one we have is a trust. Trust is governed by Indian Trust Act 1882. Along with that, various other trust acts. After that, the third one we have is a society. I am not talking about society wherein we live, but this is a form of a society which is a non-profit organization. Okay, so without wasting our time, let's begin. So as I was discussing, this chapter name is Formation and Registrations of NGOs, that is non-government organizations, also called as non-profit organizations. Okay. The weightage of this chapter is around 5 marks, and you do get the question on this. Every attempt we have seen that they ask at least one question from this. Okay, so let's begin with our chapter. Now, the very first organization we are going to learn about is the Section 8 company. But before going to the Section 8 company, I would like to introduce you what is a non-profit organization. What is a non-profit organization? Look at the word non-profit. Non-profit means what? These are such kind of organization whose main intention is not making profits. Okay, their main intention is not making profits, but it is to serve the society. Okay, to serve the society in one or other manner, in one or other manner. This is a non-profit organization. If somebody wants to do a business, want to earn a profit, can they make a non-profit organization? The answer is no, because non-profit organization, the main intention is not to earn profit, not to do business, but to serve the society. You might have seen Siddhivinayak Mandir, the different temples in India. Those all are the non-profit organization, because over there their main intention is not earning profits. Okay, you have seen various colleges, schools, all are non-profit organizations. Our ICSI itself is a non-profit organization, because over there the main intention is to promote something and not to make profits. I hope you have understood what is a non-profit organization now. So, in India, if somebody wants to constitute a non-profit organization, we have three options in India. How many options we have? We have three options in India. The first one is a Section 8 company. The second one is trust. And the third one is the society. All these three we are going to learn in chapter number 7. The details, how to incorporate, what are the tax exemptions, everything we are going to learn. Now your Section 8 company is incorporated under Companies Act 2013. It is incorporated, it is regulated under Companies Act 2013. Your trust. Now, when we talk about the trust, there are two types of trust. One is a public trust, another one is a private trust. Okay, this also we are going to discuss. So, depending upon the type of the trust, you have various trust act. Basically, it is governed under Indian Trust Act 1882. Okay. After that, when we go to the society, we have a law for society called as Societies Registration Act 1860. Okay, so these are the three non-profit organizations available in India. So if you want to promote anything, we can go further. Now, is it easy to incorporate them? No. Just because government is giving us various tax benefits, government will make sure that we are really serving something for the society. So there are a few rules and regulations for incorporation of all of them. So let's begin with the first one, that is your Section 8 company. The name itself says Section 8. So this is defined under Section 8 of Companies Act 2013. In old law, the section number of Section 25. So we used to call it as a Section 25 company. Okay. And now we call it as a Section 8 company because under Companies Act 2013 it is defined under Section 8. So what is a Section 8 company? Section 8 company is a non-profit organization. What kind of organization it is? It is an non-profit organization. So what does the Section 8 company do? What is the main object of this Section 8 company? The main object of this Section 8 company shall be promotion of art or science or commerce. You have your Chamber of Commerce, ICSI, this all is for promotion of your commerce. Then protection of environment, upliftment of scheduled caste, scheduled tribes, educating children, nursing homes, charitable institutions, etc. So your Section 8 company should have their object as promoting something. See, whenever we write a memorandum, that is object of any of the normal company which is not a Section 8 company, we always write The business of the company is so and so. But in Section 8 company, the object will be written like this. The main object of Section 8 company is promotion of. So the wordings are different. I hope you understood the difference between the two, right? So other kinds of company which are not Section 8 companies, they will be doing business for intention of a profit. And the company which is a Section 8 company, it is not doing business, but it will be promoting something. That does not mean they cannot earn profit. They do earn profit, but it is not for the benefit of the promoters. Promoters' main intention is not making profits. Okay, so I hope you have understood the object now. We are going to very important thing. Please pay attention over here. Yeah, now the memorandum of association. Everybody knows about memorandum of association, right? There is something special in memorandum of your Section 8 company. What is so special in memorandum of Section 8 company? There are certain prerequisites. So memorandum of a Section 8 company should contain this thing. So what is number one? Number one, it should contain object as promotion of, as we wrote earlier, art, science, commerce, education, nursing home, etc. So it is for promoting something. This should be the object of your Section 8 company. After that, second one, very important, their intention should not be making profits. Okay, so whatever profit they will earn, they have to redeploy for promotion of their objects. Okay, so it intends to deploy profits of the company to promote its object. To promote its object. This was very important. Okay, so whatever profits company will earn, that will be redeployed to promote its object. Third one, very important, dividend distribution is prohibited in the Section 8 company. Section 8 company cannot distribute dividend. Okay, so third one, prohibition as to declaration of dividend. Students, remember these three are the prerequisites of a Section 8 company. Like in private companies articles, we had that three things, right? One prohibition and two restrictions. Likewise, in a Section 8 company, these three things are very important, and it should be there in the object of a Section 8 company. Any of one it is missing, it is not a Section 8 company. Understood? Clear with this? Okay, so this was a memorandum, very important. After that, why should we form a Section 8 company? If I want to do some social service, why should I form a Section 8 company? So what are the advantages? Advantages are given. So when you are a Section 8 company, there are various exemptions available under Companies Act 2013. So what is the first advantage? The first advantage is you have various exemptions under your Companies Act 2013. Okay. The second one, very important, you also have exemption under Indian tax, under Income Tax Act. So you have various exemptions, or you can also say tax deductions under Income Tax Act. Clear? Understood? So these are the basic benefits given to the Section 8 company. Also, government provides you with various subsidies, various discounts. It's just because you are serving a society, and it is also the interest of the government, that's why. Okay, so these were the benefits. Now let's go ahead. Now if any company or any promoter want to incorporate a section 8 company, okay, any company want to become a section 8 or any promoter they want to incorporate a section 8 company. Can you do incorporation like the normal company? The answer is no, we cannot do. Why? Because it requires central government license. So I told you additional requirement will be there, right? So when anybody wants to incorporate a section 8 company, you need to take license from the central government. If central government gives you license, then only you can be a section 8 company. Is this requirement applicable to private or a public company? The answer is no, it's not applicable, right? So what they have to do before that, they have to apply to the central government. Where they have to apply? They have to apply to the central government and obtain license. They have to obtain a license. So once they obtain a license, after that they will get a certificate of incorporation and it will be a section 8 company. Okay. Now, once it is incorporated as section 8 company, so once license is issued, once your central government issues you a license, okay, the very first thing what you can do is, in the name of company, that is in the name of your section 8 company, you need to use the suffix as private limited or limited. Okay, so no need to use suffix. Which suffix are we talking about? Private limited or limited. Okay, so once central government issues us a license, we no longer use this suffix. Clear with this? You can use ORG, you can use federation, you can use council, you can use anything. Okay, but you may not use private limited or a public limited. This is one of the benefits given by the Companies Act 2013. I hope this was very clear to all of you. Now, important points are there about your section 8 company. So let's understand one by one. The very first very important point, your section 8 company, it can be private limited also, it can be public limited also. So a private company, it can be a private or a public. So your section 8, it can be either a private limited or it can be a public limited, no problem at all. But remember, it cannot be OPC. Okay, but cannot be an OPC. It cannot be a one person company. It can be private and can be public, no problem at all. Okay, after that, very next point, most of your section 8 company, I had told you this in your chapter number 2 also, most of the section 8 companies are limited by guarantee. Okay, where there may or may not be a share capital, where promoters of the company just give an undertaking that I shall contribute this amount at the time of winding up. Okay, so most of the section 8 companies are limited by guarantee companies. Okay, after that, section 8 company, we know that there may or may not be a share capital. So in normal company which are not Section 8 company, can a partnership firm be member of such company? Answer is no, because partnership firm is not a separate legal entity. So if partnership firm want to invest, they will be investing in the name of their partner. So partner shall be holding a stake on behalf of a partnership firm. But in a Section 8 company, your partnership firm can directly be a member of Section 8. Understood? So in Section 8 company, partnership firm can be a member of the company. Clear? Understood 3 points? Okay, let's go to the next point. Fourth one. Can we convert Section 8 company into any other kind of a company? The answer is yes, we can convert. But first we have to take approval of central government. Why? Because we took license from central government for incorporation. So for conversion also we need license from the central government. So Section 8 company can be converted into any private company or a public company. Okay, any private company or a public company, but definitely not an OPC, because it cannot be an OPC. Okay, but after complying with procedure, okay, and permission of your central government, it can be converted, no problem. Now going ahead, now the license which Section 8 company obtains, how to obtain a license will be looking after little sometime. But once license is granted by the central government, can they revoke the license? The answer is yes, because central government always gives various conditions while issuing license. So if anybody do not comply with that condition, what will happen? They will have to revoke the license. So can central government revoke the license? What are they going to revoke? License of a Section 8 company? The answer is yes. What is the answer? Answer says yes, they can revoke. How can they revoke? If they don't comply with any of the conditions given by the central government, the license may be revoked. No problem. Yes. So let's write, if any Section 8 company does an ultra vires act, which act it is carrying out? Ultra vires act to its object. We have seen now what are important thing to be mentioned in object. So any Section 8 company carries out ultra vires act of its object or breaches any of the condition, laid down by your central government. Breaches any condition laid down by your central government or does any activity which is not within the scope of Section 8. Any activity which is not within the scope of your Section 8 company. So in this case, central government may revoke the license. Okay, the license may be revoked for 3 reasons. Very important. You can just underline also. Ultra vires act done by the company, or they have breached any of the condition which was laid down by the central government. Third, they did an activity which is not within the scope of the Section 8 company. So any one activity done out of these three, Section 8 license can be revoked. So once your license is revoked, are you a Section 8 company? Not a Section 8 company. So when you are not a Section 8 company, can you use all the advantages which are available to the Section 8 company? No. Okay, so now we are going to see when the license is revoked, what are the consequences of that? Okay, so what are the effects of revocation of license? So once your license is revoked, what all things can happen? The very first thing, you are not a Section 8 company. So it is no longer a Section 8 company. So when it is no longer a Section 8 company, then will advantages, exemptions given be applicable? No. So now no more exemptions and privileges. Okay, and third, very important, Section 8 company had a liberty, no? They are not required to use suffix private limited or a limited. Now they have to add that suffix. Okay, so it has to add suffix private limited or limited to its name. Clear? Understood? Now what will happen once license is revoked? Will central government leave them? No, central will not leave them. Also, Companies Act does not provide that if somebody breaches that trust, it's not correct. Okay, so what will happen subsequent to revocation? What will happen subsequent to revocation? We saw what are the effects. Okay, there are only three effects. And what will happen after revocation? Can they continue as a profit company, profit organization? So whatever benefits they have earned when they were Section 8 company, if they breach any condition by paying small penalty, can they be leave? No, we cannot set them free, no. They cannot use all the benefits given to them when they were Section 8 into a profit organization. So what will happen subsequent to revocation? Now we are going to see that. Very first thing, if your central government, understand and write, okay, if your central government thinks that any member has done fraud, okay, fraud is done by any member of a Section 8 company, they will be responsible under Section 447 of Companies Act. 447 talks about the fraud. Okay, they shall be liable under Section 447 of the Act. Which Act I am talking about? Companies Act 2013. But yes, definitely before passing this order, before making that member responsible, always central government shall give opportunity of being heard. What it shall give? Opportunity of being heard will be given to the member. Clear with this? The first one. Now what will happen second thing? Now central government will evaluate that what Section 8 company has done, and it will order, okay, the condition is breached, that is correct, the license is revoked. So now can Section 8 company be operative? It can be operative and it will order. Okay, see, once license is revoked, central government has two options. Okay, so central government can order any one of it. The first order can be for amalgamation with other Section 8 company. amalgamation with other section 8. So central government will order that just because your license is revoked, you have all the assets available. So already there is a section 8 company, you get merged with that. Okay, you cannot operate on your own because license is not there. So you go with that company. Okay, that is the first order. What will be the second order? Central government can order winding up only in case of a public interest. Okay, so central government can give two orders. One is amalgamation with other section 8 company and another order will be winding up, but this will be purely when it is in public interest. Okay, so when it is in public interest, only then it can order for winding up. So please remember, whenever central government has revoked the license of section 8 company, it has two options. Okay, so it may order either for amalgamation or for winding up. Okay, now next one. Whenever it orders for the winding up. Okay, so whenever it orders for winding up, what will happen? Whatever assets are there of section 8 company, so assets are realized. Okay, liabilities will be paid off. Whatever liabilities are there, so liabilities shall be paid off from that. And whatever balance remains, okay, if balance is positive, suppose after paying off all the liabilities, now your section 8 company has 10 lakh rupees surplus. So can they distribute among the members of section 8 company? The answer is no. Members of section 8 company shall not get the surplus in case of a winding up. So where will this surplus go? This surplus, okay, whatever is surplus there over here, the surplus either it shall be paid off to other section 8 company. Similar kind of section 8 company is there. Okay, so surplus is there, it will be paid off to that section 8 company as a donation, or there is a fund called as insolvency and bankruptcy fund. Okay, it shall be paid off or transferred to the insolvency or the bankruptcy fund. So when winding up is ordered, okay, asset shall be realized, liability shall be paid off, balance if any, it might be either paid off to the other section 8 company or transferred to the insolvency bankruptcy fund, but in no case it shall go in the hand of your members of a section 8 company. Clear with this? Understood till now? That's great. Now the last part of this, in case there is a default. Okay, so in case company defaults in complying with order of your CG. Can we default in complying with order of CG? If central government has told us to do something, we have to do it. If we default, we are liable for the penalty. Okay, so they shall be liable for the penalty. Now what is the penalty for the company? Company is an artificial entity, right? So we cannot put it in the jail. So company is an artificial entity, so it cannot be put inside the bars, right? So the penalty for company shall be fine of minimum 10 lakh rupees. It can also go up to 1 crore. So 10 lakh to 1 crore shall be the fine to the company. And what about a penalty to the officers in default? Officers in default means what? The person who have actually worked in that, actually done the default. because directors are the person who actually do the transaction, right, on behalf of the company. So they are called as officers in default. So for them, CG can order imprisonment up to 3 years, okay, or it can be fine minimum 25,000 rupees to maximum 25 lakh rupees, okay, or it can be both also, or it can be both. One more penalty for them, they shall be liable under section 447 in case they are liable for the fraud. So these are the penalties, okay, which every company or officer in default have to go by if they default by the CG order. So I hope you have understood what is a section 8 company over here, okay. Then why we form a section 8 company, what are the requirement of a section 8 company, please remember the memorandum part. Also remember what will happen if there is a revocation of license by a central government, okay. Now let's start with the incorporation of section 8 company, then we'll be learning features of section 8 company and then exemptions of section 8 company, okay. So let's quickly start with the procedure for incorporation of section 8 company. Whenever we want to incorporate any company, the first thing we require is a name. Can we take any name of any company? The answer is no. We have to follow the rules, right? So let's see what are the rules. So first one is the name application. Now this name application has to be as per what? It has to be as per Emblems and Names Act 1950. Also, your name should be as per Incorporation Rules. It is Company Incorporation Rules 2014. Also, your name should contain certain words because it's a section 8 company, will not be affixing private limited or public limited to it, okay. So the section 8 company name should contain words like federation or chamber or council or ORG, etc. Okay, so name of your section 8 company should be as per this rules. So once we have selected the name, the second thing we need to do, apply for reservation of the name. So we shall be reserving the name. How do we reserve the name? A new company can reserve name only through Spice plus Part A, right? So we are going to reserve our name through Spice plus Part A. Can we reserve our name through run application? The answer is no, we cannot do that. So once we have applied for it, once ROC approves our name, okay, the name is valid for 20 days, and I have taught you if you want to extend this 20 days, you have to again file the form, right? So it is valid for 20 days. Now we have to start preparing, okay. We have prepared two sets of documents, one for incorporation of company, another one for obtaining license. For incorporation of company, we already know what are the documentations, right? So we will be concentrating on what are the documents required to obtain a license from a central government, okay. So preparation of documents for obtaining license, Okay, so we are going to apply to whom? We are going to apply to the central government. Now, which form is there for application of license? Application of license is done in form number INC 12. Which form is there? INC 12. We apply for application of license. Okay, so INC 12 is nothing but application done to the CG for obtaining license from a performing a Section 8 company. Now, to this INC 12, what all attachments we shall be doing, that is important. So, first thing we need to attach is draft memorandum and articles. Okay, draft memorandum and draft articles. Can your memorandum and articles be like normal private or a public limited company? The answer is no. I have told you they are the special memorandum and special articles. So, this has to be as per INC 13. So, INC 13 is format of memorandum of association, okay, and articles of association. This is the first thing we need to attach. Second one, we need to attach a declaration from professional. A declaration from professional. Now, in which form? It will be in INC 14. Now, what will professional certify? The professional can be the practicing company secretary or a chartered accountant or a cost accountant, that is okay. But what they will certify? They will certify as to the format of memorandum and article has been complied with. So, your company's memorandum and articles are as per your Section 8 company rules only. So, that is what is a certification which will be done. After that, the next attachment, it will be future estimate of your income and expenditure. Okay, future estimate of your income and expenditure of at least 3 years you have to give. So, how you think what will be your income, that is a source of income, and what all expenditure you think. So, for next 3 years you have to give this future income and expenditure estimates. After that, one more declaration, and this declaration will be by your promoters that they want to form a Section 8 company. It will be a non-profit organization, and this they need to attach in INC 15. Okay, so these are the basic documents required for application of license to the central government. First, memorandum articles, that is INC 13, INC 14 declaration by professional, INC 15 will be declaration by the applicants, and future estimate and of income and expenditure for at least 3 years. Okay, this will be the attachments in INC 12. We've already seen. After this, the next point will go, point number 5. If your central government thinks fit, okay, then it may give you a license. It may issue license. Okay, students, practically when we do this procedure, the procedure for obtaining the license and also for incorporation of Section 8, we do it combined way. They are the linked forms. Okay, so SPICE plus along with that INC 12, both are filed together only. Together only you will get license. So once license is given, ROC may give you a certificate of incorporation. Clear with this? Understood? So after this, the 6th point, we have to start the incorporation of company. So once license is issued, we can start for the incorporation of company. So we have to make sure about certain things. We have to look into whether your all directors have DIN or not. So we have to see to it, because at least one director has to be resident Indian. Even that we need to check, right? After that, all subscribers shall have DSE. That is a digital signature because memorandum article shall be signed digitally only, right? Then when you are a private limited, how many members you require? 2. When you are a public limited, how many members you require? Minimum of 7. Don't say 3. I know many of you have said 3. Okay, so after this, you know what are the incorporation documents? You have to draft the incorporation document. So once incorporation documents are drafted, then you have to file the incorporation documents in Spice Plus. So file incorporation form, that is in Spice Plus Part B. Clear with this? Understood? Okay, so once this incorporation form is submitted, once we submit the form, once the form is submitted, we have to pay fees for incorporation. What we have to do? We have to pay the fees for the incorporation. Okay, so over here we are only supposed to pay the incorporation fees. We are not supposed to pay the stamp duty fees. Why? Because for incorporation of Section 8 company, stamp duty is exempted. Okay, so one more privilege given by the government. Only incorporation fees, stamp duty is exempted. Okay, now we shall see what are the documents we will be filing in Spice Plus. Basic incorporation document, then one additional one. So you can revise it. INC 9 everybody knows, declaration by directors and the subscribers. After that, directors consent, that is DIR 2 plus DIR 8. Okay. After that, the registered office documents. Right. After that, we require memorandum and articles. Now the last one, we require affidavit. Okay, this is the additional document required. Affidavit from all the directors. It will be on 100 rupees non-judicial stamp paper. Okay, so what will they say? Directors shall state in the affidavit that they have not accepted deposits or they are not accepting the deposits. This is a declaration all the directors have to give on the non-judicial stamp paper. I hope it was very clear. So this was your incorporation of a Section 8 company. So after verifying all the documents, if ROC thinks fit, it shall issue a certificate of incorporation. So your Section 8 company has been incorporated now. Okay, so that was all for incorporation. Now we'll see some features of Section 8 company. Let's go to your notes. So some features of Section 8 company. Most of them we have discussed. Okay. First, what will be the main object? It will be for promotion of commerce, art, science, sport, education, research, social welfare, religion, charity, protection of environment or any such other object. So you have to remember at least 7 to 8 points from this. Okay. Then profits will deploy it in promoting the object. They will not be distributed among the members. So it prohibits distribution of the dividend. Then name of the company can be incorporated without using private limited or a public limited. We have discussed this as well. There is no requirement of a paid up share capital for any company. We don't have any requirement of paid up share capital now. We can incorporate company even with 10 rupees, no problem. Now it is exempted from the stamp duty. Okay, I have already told you they need not pay the stamp duty for incorporation. Also, there are many privileges, exemptions available to Section 8. We are going to see that. Can one person company be a Section 8 company? No. Section 8 company cannot be incorporated as one person company. cannot be converted into one-person company. Okay, now tell me, can Section 8 company be a small company? Again, no. It cannot be a small company. After that, it is an independent corporate legal entity. Okay, it is same like your private, public, LLP. It has all the features of your company, just that it is a non-profit organization, and because of non-profit organization, it has various privileges and the exemptions. Now we are going to start with privileges and exemptions available to a Section 8 company. Okay, we have seen various exemptions. We have seen about private, we have seen for OPC, for Nidhi company, we have seen government company, we have seen. Now we'll see exemptions available to the Section 8 company. The very first exemption available. Now your question will be, ma'am, how do they ask in the paper? They may ask you direct question, or they may ask you in the form of case law. So it's very important, we have to remember all the exemptions. The very first exemption says that Section 8 company is not required to appoint a company secretary. Okay, even though its paid up share capital is more than 10 crore rupees, no problem at all. They don't have to appoint a company secretary. It is for the cost cutting of the company, because company is not doing a business, that's why. Okay, so it's not mandatory. Then it does not have any minimum share capital requirement also. This is same like your private, public, all other. After that, it can call the general meeting by giving 14 days notice instead of 21 clear days. For normal companies like public, private, which are not a Section 8 company, how many days notice we give? We give 21 clear days. But in case of a Section 8 company, only 14 days notice is there. Understood? Can you call it shorter notice? The answer is no. Section 8 company don't have to comply with the shorter notice provision. But for them, instead of 21 days, law only says you have to only give how many days notice to the shareholders? 14 days notice. So 14 days notice will be required to convene a general meeting. After that, it's not mandatory for Section 8 company to record the minutes. Okay, but listen to this. If articles of Section 8 company says that the minutes of the meeting are to be recorded within 30 days, so articles of companies requiring company to maintain the minutes book, then they have to maintain. But law does not provide for any minutes requirement for a Section 8 company. So recording of the minutes will no longer be applicable, but the minutes may be recorded within 30 days of conclusion of meeting, where company's articles provide for circulation of minutes. Okay. After that, in every annual general meeting, financial statements of the company are laid before the shareholders. Yes. And when we give the notice of the annual general meeting, along with that notice, we also give them financial statements. So every company give financial statements at least 21 clear days before annual general meeting. But in case of a Section 8, are we giving 21 days notice to them? No, we are giving 14 days notice to them. So on the same lines, the financial statements of the company shall be delivered to the shareholders before 14 days only and not before 21 days. So instead of 21 days, 14 days will be applicable. Now, what is the requirement for number of director? Actually, Section 8 company does not have any requirement for director. So, no Section 8 company, Section 149 is not applicable to a Section 8 company, because 149 talks about the number of directors. In private company, 2 directors. In public company, 3 directors. In OPC, minimum 1 director. This requirement is not applicable to Section 8. And you will say, ma'am, why did you say 2 directors? I said 2 directors because the quorum, you understand what is a quorum? Quorum means minimum number of members or minimum number of directors required to start board meeting. Okay, so even though Section 149 subsection 1 is not applicable, but quorum for board meeting has been kept as 2. So be it a public company, be it a private company, does not matter. The minimum quorum requirement is 2. So government company, so Section 8 company has to have 2 directors on its board. Even though it's a private limited or a public limited, does not matter. So even though it's a public limited, board of directors of Section 8 company may have only 2 directors. Simple. Okay. After that, independent directors are not required. Section 8 company are not required to appoint an independent director. Very simple. After that, Section 8 company need not convene its first board meeting within 30 days of incorporation. Normally, your company should convene its first board meeting within 30 days of incorporation, but Section 8 company is not required to do so. However, it has to convene its first board meeting at least once in 6 months. Okay, so 2 board meetings in a year. After that, right of person, that is candidature, Section 160. So any person other than retiring director can stand for candidature, but this is no longer enforceable in Section 8 company. Understood? After that, for counting number of directorship, we know that a person can be director in only 20 companies, but for counting the 20 companies, Section 8 company will not be counted. Okay, so I can be director of 25 Section 8 companies, no problem. So for counting this 20 companies, Section 8 company has been relaxed. So an individual, if he is eligible, can be director in more than 20 Section 8 company, no problem at all. Also, Section 8 company don't have to form certain committees. Now there are certain committees which every company have to form if they exceed some threshold. Section 8 company is not required to have nomination and remuneration committee who takes care about the appointment of directors and the remuneration. Also, it is not required to have a stakeholders committee. Okay, please remember this. After that, certain decisions, okay, in a company are to be done at the board meeting only. So whatever decisions are there in Section 179, they have to be done at the board meeting. You cannot do circulation by resolution. But in a Section 8 company, your decisions under 179 can be taken by way of circulation, no problem at all. So instead of calling board meeting, the resolutions will be sent to the residence of each and every director. Director can sit there and they can take decisions, no problem. Okay. So now the last exemption of the Section 8 company is about your related party transactions. Okay, related party transaction is given under Section 188. So all, we are just talking about the Section 8 company over here. Okay, so directors' interest shall be disclosed. So suppose any firm is there, any partnership firm where your director is a partner. That firm is making contract with the Section 8 company. So there is a interested director. So any firm wherein your directors are interested, they have to disclose the interest. The director will be required to disclose his interest in any firm where company is making a contract. But when they have to make this disclosure, they have to make disclosure only and only if the arrangement value exceeds 1 lakh. So if arrangement value does not exceed 1 lakh, they no need to make this disclosure by the director under section number 188. Okay, so I hope you have understood all the exemptions under Section 8 company. Along with that, you have understood what is the incorporation procedure of Section 8 company. So now let's begin with the trust. When your trust is a non-profit organization. Okay, what is a trust? It's a non-profit organization. In this video, we'll be learning what is a trust, what are the kinds of the trust. There are 2 kinds of the trust, public trust and a private trust. The distinguish between the two, and recently in December 21 attempt, distinguish between public and a private trust was asked. And how to determine whether any trust is a public or a private. We are going to learn that as well. Along with that, what are the exemptions available to the trust? So let's start. So what is a trust? I told you trust is a non-profit organization, because in this chapter we are only learning about non-profit organization, right? Now let's understand the concept of a trust. I'll give you an example. Suppose there is a wealthy man. Okay, wealthy man has huge properties, huge business, huge properties, but he is all alone. He has only one son. Okay, and this son is also a minor. But this wealthy man, his health is not good. He is sick. So he is worried. What will happen if something happens to me? Who will take care of my property? Who will take care of my son? If somebody will do fraud with my son and take away all the property, what will my son do? So he has so many doubts in his mind. Okay, so a very intelligent student like you who become a company secretary, he advised that wealthy man to create a trust. Okay, what was advised? To create a trust and transfer this huge property in the name of trust. So when the trust is created, okay, there is a tripartite agreement. Trust is created, there is an agreement. Agreement between whom? The wealthy man, the trustee. He will obviously appoint a trustee to take care of the property, and last one is a beneficiary. So who is this wealthy man? You can call this wealthy man as a settler. Who is a settler? The person who creates a trust is called as a settler. So over here, wealthy man is creating a trust. So he is a settler? Yes. After that, trustee is a person who is appointed by a settler to take care of the property. But does this property belong to the trustee? The answer is no. Trustee will take care of the property for the benefit of the beneficiary. So who is beneficiary in our example? That minor son. This is a concept of a trust. So if something happens to that wealthy man, now he does not have any problem because he has transferred all his property to the trust. Trustee will be managing. But will he be managing for his own profit? The answer is no. He will be managing for the benefit of the beneficiary. Now you will ask me, ma'am, then why trustee will do this? Is he doing charity? No, trustee will get the salary. He will get salary for whatever he is doing, but his interest will not be there in the property because property belongs to the beneficiary. So whatever is good for the beneficiary, he will do all the things for that trust property. Okay, clear with this? So trust will be created, property will be transferred, trustee will be appointed, and this is how your trust is created. So now let's understand what are the essentials of trust. What is requirement of trust? Essentials of trust. The very first thing is your settler. We require a settler because he will be transferring his property, right? If there is no property, there is no intention, why trust will be created? So his clear intention is very important, and whose intention? Settler's intention is very important. There has to be a settler, there has to be a beneficiary for whose benefit the trust is created. There has to be trustees. Okay, why I write trustees? Because minimum 2 trustees are required to form a trust. Okay, minimum 2 trustees. After that, we require a trust property, because trust cannot do any other business. It can only manage the property, take care of the property, and do all the things required for the property. It cannot do any other business. Please remember. And very important thing which is required for the trust is intention. Intention of settlor is very, very important. It should be very clear intention. If settlor says that I may create a trust on my property, is trust created? No. I shall create a trust, not created. So what you have to write, I hereby create a trust for my property by transferring my property to this trust in the name of this trustee. This is a clear cut wording we require in our trust. Is it clear? These are the very important 5 essentials of the trust without which trust shall not be created. Okay, understood? Now let's move on to the next. Now whatever trust this person has created, wealthy man created trust for his son. So can I say this is a private trust? The answer is yes. Okay, so whatever trust he has created, this trust is a private trust. Why I call it as a private trust? What is the definition of a private trust? Private trust means where beneficiaries are asserted. Okay, so what is a private trust? Your beneficiaries are ascertain. You know who all are your beneficiaries. They are very, very definite. They may be 1, 2 group of people, does not matter, but they are not public at large. Beneficiaries are not public at large. So they are determined, they are ascertain, they are not public at large. This is called as a private trust. Clear with this? Great. Now, whenever we have a private trust, I hope you have noted down all this thing. Okay, so now let's proceed to the next slide. If you have not noted down, you can just pause the video and note down, no problem. So now basically there are 2 kinds of trust. First trust is a public trust and another one we have is a private trust. So public trust and a private trust. So which law is governed? Which law governs this public trust? So it is governed by, along with understanding what is public private trust, we are also writing the distinguish between the two. Okay, so it is governed by Bombay Trust Act. Is governed by whom? Bombay Trust Act. Also by Charitable and Religious Trust Act. Also by Charitable Endowment Act. Also by Societies Registration Act. Okay, so when you are a public trust, so many laws will be governing that trust. Okay, because many tax exemptions are given to them. Now the private trust, it will be only governed by Indian Trust Act 1882. Private trust will not be governed by so many acts because over there the beneficiaries are determined. When they are determined, he is not doing for the public at large. So even though he is a non-profit organization, is he serving the society? The answer is no. So will he get the benefits? The answer is no. So benefits are not given, that's why no more laws are. I hope this was very clear. Now second point talks about the beneficiaries. What about the beneficiaries in a public trust? The beneficiaries in the public trust are public at large. Okay, they are public at large. Any person can be beneficiary in this. So they are unascertainable. They are unascertained or they are undetermined. You cannot determine. But what about the private trust? They are not public at large, but the beneficiaries are very, very particular. So over here we have particular beneficiaries. They are ascertained and determined. Okay. So this was your beneficiary. By looking at the beneficiary, you come to know whether the trust is public trust or a private trust. I'll give you an example, then you'll understand. Now what about the tax benefits? I have discussed this earlier. Tax benefits will be available to whom? Public trust or a private trust? Very good, it will be available to a public trust only. It will be enjoyed by public trust. On the other hand, tax exemptions are not available. Tax exemptions are not available to the private trust. I gave you the reason also, because they are not serving the society. That's why. What about the donation? If you want to donate, will you donate to the private trust? No. You will donate to the public trust only, because there you know it is for the society as a whole. So public trust receives donations. Donations are granted to this public trust. Over here, no donations are granted. Donations may be given by the settler himself, the relative may be himself, but it is for a particular group of people. So it is not a public trust, hence donations are not received. Donations are not granted. Clear? Understood? The difference between. So I hope you have noted down the distinction between the public trust and the private trust. Now I'll give you an example of a public trust or a private trust. You have to determine whether it is public or a private. Okay? There is a company called as Reliance Industries. Now this Reliance Industries, it opened canteen. Okay, and this canteen over here, free food was given to all the employees who are working in that Reliance Industries. Okay, and this canteen was opened under one trust. Trust was created for that. So I hope you have understood. Reliance Industries opened a canteen, okay, and property was transferred to the trust. Trust will be managing that, and under this, food will be given free of charge to all the employees. Now tell me, this trust is public or a private trust? Which kind of trust it is? It is a public trust or it is a private trust? How do you determine this? You have to go back to the definitions of public, private. In public, the beneficiaries were not determined. They were public at large. But if we compare to the private beneficiaries are determined. Did I say that under private beneficiary cannot exceed 200, 300? No. But when beneficiaries are defined, it's a private trust. I think you got your answer. So this trust is a private trust. Why it is a private trust? Because beneficiaries are defined, determined. So all the employees of Reliance shall get free food. Is it open to all the public at large? The answer is no. Now think about one temple. In few temples, people get free food. So that is public or a private trust? That is a public trust. Why it's a public trust? Because it is open for public at large. Clear with this? Understood? Simple? Great. Okay, this same question was asked in December 21 exam. Students were so happy by looking at this question. Ma'am, you had taught us this, and they literally asked whether it is public trust or a private trust and give difference between a public and a private trust. So easy it was. Okay, so let's go to the next one. Now, there are certain other examples of trust. Other examples of trust. Now, along with the public and a private trust, there are other trusts also called as SEBI registered trust. There are certain trusts which are registered with the SEBI. Okay, what are those trusts? Mutual fund trust. It can be venture capital trust. Or it can be real estate investment trust. Okay. When we talk about the foreign direct investment, can foreigners invest in the trust? The answer is no. Foreigners cannot invest in the trust, but they can invest in the SEBI registered trust. So foreigners can invest in the mutual funds, foreigners can invest in the real estate, foreigners can invest in the venture capital trust which are registered with SEBI, but in other kinds of trust they cannot invest. I hope you understood this. Okay, now further going to the next one. Trust can be further classified as two types. Okay, first we saw what is public, private, then we saw other kinds of a trust. Now going to classification of the trust. Now this classification of the trust is private trust. So private trust can be further classified into two kinds. One, discretionary trust, and another one, non-discretionary trust. Okay, so your private trust can be further classified into two, discretionary trust and a non-discretionary trust. Now, what is a discretionary trust? Now, let's take an example. There is a father. He created a trust, transferred property to the trust. Okay, and this father has 4 sons. How many sons he has? Father has 4 sons. So he has created a trust, transferred the property, and ultimate beneficiaries are these sons. So these sons are the ultimate beneficiaries. So in the discretionary trust, okay, how much stake they are holding? The stake of 4 sons, son 1, son 2, son 3 and son 4. So this is the kind of trust where percentage stake of each beneficiary, okay, percentage stake of each beneficiary is not defined. Okay, so all these 4 sons, they know they are holding some percentage in this trust, but how much it is not determined. It will be discretionary. Discretion means it will be discretion on the trustee, or it can be discretion of the settlor also. So any point of time, settlor can declare the trust as discretionary to non-discretionary. Father may say, let me see which son serves me the most. Whoever will serve me the most majority property will be handed over to them. So the right, the percentage stake is kept with whom? The settlor or the trustee. So discretionary trust means what? The percentage stake of each beneficiary is not defined. Please remember. Okay. And what is non-discretionary? In non-discretionary, the percentage stake of each beneficiary is defined. Okay, so when we take this example, in one particular trust, 4 beneficiaries are there. So each beneficiary will be holding 25% of the stake. So over here the percentage of stake is defined. Such trusts are called as non-discretionary trust. I hope you understood. So let's revise. Discretionary trust means where percentage stake of each and every beneficiary is not defined, and non-discretionary means where percentage stake of each and every beneficiary is determined or defined. Clear? Understood? These are the classification of a private trust. Okay. Now let's go to the next. I hope you have taken it, or you can take the screenshot also. Now we are going to the next. Why we learned this discretionary and non-discretionary? Because on this we'll decide who can be trustee of both of this trust and also about the tax exemptions. Okay. Yeah. So in case of discretionary trust, who can be a trustee? In case of a discretionary trust, only a person who is competent enough as per Indian Contract Act can be a trustee. So only competent person can be a trustee. Okay. But what about the non-discretionary? In non-discretionary does not have to take any decision about the percentage of stake, right? So in non-discretionary, trustee can be any person who can hold the property. Okay. So any person who can hold property can be a trustee. Clear with this? Understood? In case of discretionary, only competent person can be a trustee. In case of a non-discretionary, any person who can hold the property can be a trustee. Simple. Okay. Now, next question. Who can create trust? Who can create trust? First one, a company can create trust. The answer is yes, no problem. Company can create trust. Second one, any woman. Even woman can create trust. Yes, if she is holding property, she can create a trust, no problem at all. Association of person can also create trust. The answer is yes. Association of person can also create trust. So partnership can also create trust, no problem. Any HUF, Hindu Undivided Family, can also create trust. Any person who is competent to contract. Indian Contract Act we have seen, right? Who is competent to contract. So any person who is competent to contract can create trust. Yes, no problem at all. Now the last one, can minor create a trust? Just imagine one situation. Remember I give you example of a wealthy man. Suppose wealthy man did not create trust and he died, leaving behind his minor son and huge properties. Can his son handle the property? Answer is no. So what that minor son can do? Can minor son create a trust? Directly cannot create a trust, but minor son has to approach principal civil court, where they have to approach principal civil court. Generally your principal civil court is none other than your district court. Every district has its court, right? So principal civil court he has to approach and he has to take permission of principal civil court, saying that my father has left huge property, I am not able to handle that, please create trust for me. So principal civil court is not holding the property. So can principal civil court be settler? No. ultimately when father dies, the son became the owner, he is a settler. So over here, with the permission of principal civil court, minor shall create a trust. So with the permission of principal civil court, minor can create trust. This may be asked in the form of a case law. I hope this is clear. Right? So who can create trust? Please remember, company, woman, association of person, HUF, any person competent to contract, and even minor can with permission of principal civil court. Clear? Understood? That's great. Now, let's go to the next. Exemptions. That is tax exemptions. Exemptions under Income Tax Act 1961. Now tell me one thing, which trust will get the exemptions? Obviously only and only your public trust. Okay, so we are going to see tax exemptions which are available to the public trust. Okay, so let's start. The first exemption is given under section 10. Now is this section 10 of your Companies Act? No, it's section 10 of your Income Tax Act. Okay, so under Income Tax Act, under section 10, total tax exemption is given. What is given? Total tax exemption means entire income from that property or entire income of that trust is exempted. No need to pay a tax or even a rupee of that. Okay, so total tax exemption. Now this will be applicable to which kind of a trust? It will be only applicable to trust which are related to, please remember this, sports. Okay, trust related to sports, trust related to education, trust related to scientific research, trust related to promotion of hospitals, also khadi industries. You have to remember this specifically. Okay, so total exemption will be given to trust relating to sports, education, scientific research, promotion of hospitals and khadi industry. Here with this, understood? Now, when there is a trust relating to this, the other requirement is this all, I'll be writing it here only so we can complete the point in this page. This all trust should be notified as a charitable institution. Okay, we need to be notified as charitable or religious trust. So if they are this kind of trust relating to sports, education, scientific research, promoting hospitals, khadi industry, and they are charitable trust or religious trust notified, then they will get total tax exemption under section 10. Very clear with this? Great. Now we are going to the next section. Section 11. Now what about the other kinds of trust which are not covered under section 10? So other trust may also get the exemption if they are holding the trust property for the public. Okay, so trust will get exemption who holds the property for public trust only. Now just understand this. I'll give you an example. Now there is a temple. Okay. Now there is a property of this temple. Now this property over here two divisions are made. 80% of the property, it will be created for the public at large. Okay, it will be for the public at large. You can come here, eat food, etc., etc. And 20% of the income of this property, it is for the person who are taking care of temples. So I can say Mr. Pujari and family members. So 20% of this trust property will be for benefit of Pujari and its family members. So the 80% part, this part I can say that trust is holding property for the public. This is a public trust, and this 20% will be a private trust. So who will get exemption under section 11? Only income derived from this 80%, and this 20% will not get any exemption. Is it clear now? Understood? Good. So now other trusts, if they are holding property for the public only, they will get exemption. Okay? Yes. So what exemption will be given to them? Whatever income is generated, from trust property for charitable or religious purpose. Okay, charitable or religious purpose, that income shall be exempted. So I already gave you example. 80% of share shall be exempted. So whatever income is received by this 80% of property, that will be exempted, and this 20%, it is for the private people. It will not be exempted. Simple. Great. Okay. Now there is exemption to above rule. Exception to above rule. Now what is the exception? The above rule which they say income generated shall not be applicable. So exemption will not be given. Okay. So above rule shall not be applicable in following cases. So in which cases the above rule is not applicable, we are going to see. The first one, income is generated from such a property which is held for the private trust. From the property held for private trust. Remember our 20%. Okay. Yes. So this is for the private trust. And second one, whatever income is generated, okay, trust can invest that, no problem at all. But they have to invest only in the recognized securities or approved securities by income tax. If they invest in any other security, exemption will not be granted. Okay. So over here, investment in non-approved securities. Are not exempted. So even though you were holding property for public only, but that income you invested in the non-approved securities, the exemption will not be applicable under section 11. So under section 11, what is the rule? Whatever property you are holding for the public trust, income generated from that will be exempted. But which part will not be exempted? Whatever part you are holding for the private trust, or you are investing the income received in the non-approved securities, will not get the exemption. So I hope section 10, section 11 both are clear. Okay, let's go to the next section, section 12. Now, whatever trust property are held, okay, whatever trust property are held for public or charitable institution or charitable purpose, that is totally exempted. So whatever income we earn for property earned for charity or public, it is totally exempted, right? This is the first point. Next, listen to this very carefully. Whatever income is earned, okay, out of this 25% can be set aside for your administrative expenses. Okay, what do I mean? Suppose I have earned 100 rupees. Out of that 100 rupees, 25 rupees I can set aside. Set aside means 25% I can use for looking after of my temple, because when I have to clean the property, okay, do various services, give salary to people. So those are the admin expenses. So out of 100 rupees, 25% can be set aside for administrative purposes, that is okay. But beyond 25% if you keep, it will be taxable. Clear? Understood? So if you are earning 100 rupees out of that property, it is totally exempted. And if you keep 25 rupees out of that for administrative, even that will not be taxable. But if you keep 35 rupees for that, 10 rupees shall be taxable, because you are using it for non-approved use. Clear with this? Okay. So how much can be set aside? 25% can be set aside for the administrative expense. Clear? Now the next point under this. Before Income Tax Act 1961, if anybody has acquired a property, okay, so property acquired before 1961. So when we have acquired property, property has been acquired before 1961. Now what is the provision for this? Now this property which we have acquired before 1961, this is for the trust, okay, but this half of the property, that is partially, it is for public trust and partially it is for private trust. So entire property is not for the public trust. Then also this entire income earned, okay, listen to this very carefully. Income earned shall be totally exempted. Income earned shall be totally exempted. Just because it is held for private trust, it will not be taxable. So before 1961, if anybody had acquired property, okay, then for them this rule is applicable. Which rule? Even though you are holding property partially only for charitable, entire income earned from that property totally tax exempted. Clear? Understood? Yes. Apart from this, 25% of income can be set aside for administrative expenses, no problem. Okay, so this was the provision for property acquired before 1961, because before that Income Tax Act 1952 was applicable, so it had a different provision. Clear? Understood? Yes. After that we have seen, okay, let's number the points. This was A, this was B, this was C point. Now we are going to the D point. D point under section 12. Okay. Now, if property was acquired before 1952, okay, Property was acquired before 1952. Now what is the provision? Listen to this very carefully. Property which was acquired, property was held for charitable purpose. For which it was held? Charitable purpose. Okay. Plus whatever income earned out of it. Okay, income earned out of the property was spent outside India. Was spent outside India. In this scenario, whatever income was spent outside India, this was exempted. Now you will say, what kind of provision was this? Just remember, before 1952, it was a pre-independence. So your Britishers were there. They will always require money, right? That's why this provision was made. Okay. So whatever property was acquired before 1952, if you are spending that income earned out of that property outside India, then you will get total exemption on that. Clear with this? That was a D point. After that, E. Whatever voluntary contributions are received or voluntary donations are received. Voluntary contributions or voluntary donations, entire thing is exempted. Because trust will obviously receive the grants, right? So if you put tax on it, trust will not be willing to accept the grants and gifts. Clear with this? So voluntary contributions or donations are totally exempted. It is not a taxable income. After that, if you have made a charitable trust or religious trust for a particular section of a society which is socially, economically backward, like social, scheduled caste, scheduled tribes. Okay, so it is for socially and economically backward class. Okay, then whatever income is earned, it will be totally exempted. Clear with this? Understood? So this is your section number 12. In section 12 we saw how many points did we see? F points. So many points we saw. Okay. So section 10, 11, 12 tells about the exemptions available to the public trust. Exemptions are only available to the public trust. Now the last part of this video will go to the private trust. Okay. How is the tax arrangement for the private trust? Oh, very important thing. Do private trusts receive or have any of the exemptions? The answer is no. So no exemptions are available to the private trust. Okay, no exemptions available to the private trust. So this private trust will be taxable as per the two classifications. There are two kinds of private trust we have already learned. One is your discretionary. Another one is a non-discretionary. I hope everybody remembers this. If you don't remember, please go through the notes first. Discretionary means where percentage stake is not defined, and non-discretionary means where percentage stake is defined. So what will be the tax application? What are we going to see? What will be the tax arrangement as far as non-discretionary is concerned? For non-discretionary, remember, the percentage is not defined. So nobody knows that how much beneficiary is holding. So can it be taxable in hands of beneficiary? No. So it will be taxable in hands of trust only at maximum marginal rate. Which rate? Maximum rate. That means you have a slabs, right? 10%, 20%. So whatever is the highest slab, 40%, that is the maximum marginal rate. So in case of a discretionary trust, whatever income is there from the property, it will be taxable in hands of trust only at 40% or the higher, the maximum marginal rate. What about the non-discretionary trust? Non-discretionary means percentage is known, right? So whatever is a percentage, as per that only the will be taxable. So under non-discretionary, it will be taxable in hands of beneficiary. Simple example I can give you. If 100 rupees is earned out of the trust and each beneficiary is holding 25%, so 25 rupees each is income of beneficiary. The 25 rupees would be added to the income of the beneficiary. Clear? So under non-discretionary trust, it will not be taxable in hands of trust, but it will be taxable in hands of beneficiary. Okay? So income shall be added in beneficiary's income. Understood about the private trust arrangements? Great. Now the last point. See, basic rule is trust cannot do any business except of handling of the property. So if trust carries on any other business or carries on any business except of managing the property, the trust is carrying on business except of managing the property, so they are doing a default. What is trust doing? It is doing a default. So they have to pay the penalty. What is the penalty? Penalty is they have to pay the tax on income earned at maximum marginal rate. Okay, so no exemptions will be available to them, but they have to pay the tax on maximum marginal rate. So trust cannot do any business except of handling the property. Okay, now let's start with formation of a trust. We've already discussed what are the essential requirements of the trust, right? The essential requirements are settlor, beneficiary, trust property, two trustees, and intention of the settlor. If this all things are there, we can create a trust. So for creation of trust, what all things are required, we are going to see. The very important, who can create a trust, we have also seen that a company, association of person, competent person. So who is a competent person? Any person who is above 18, who is mentally sound and capable of understanding is called as a capable or competent person. So he can create a trust. Exceptions we have seen, minor, right? So before registration, we have to check following aspects. What are the aspects? The name of the trust. We have to give name to our trust. Address of the trust we have to check. We should see the object of the trust, whether it is for charitable or it is for private. We have to check that. There has to be at least one settlor, because if any person is not transferring the trust property, how are we going to make trust? Minimum 2 trustees are required as discussed earlier, and property of trust is very important. The property can be movable or immovable property, that is not important. But your trust deed is always on the non-judicial stamp paper, and value of your stamp duty will be determined on the value of property. Okay, so in order to save the duty, initially settlor creates trust by just transferring a token amount like 1000, 2000 rupees. So stamp duty will be paid on that 1000 or 2000 rupees. You need not pay the entire value of property. So once trust is created, then he can transfer the property. So then you no need to pay a stamp duty. Okay. Now, creation of a trust. Is it compulsory that we should have a deed in writing? Yes. We should have a trust deed. And this deed has to be in writing. Now, what about the language of this deed? Do you actually need to hire a lawyer or a company secretary to draft a deed? You can, but it's not compulsory. Because language of the deed can be the layman's language. You can use any language. Technical words are not required. So what is required in the deed? Deed has to be written. It has to be on the non-judicial stamp paper. And over there, the intention has to be clear. So even though technical words are not there, but the intention of settler should be very, very clear. It should not be unclear. Okay. So it can be created in any language. Any language. It's not required that it should be in English language. No. But what should contain? It should contain an intention, and no technical words are necessary. It's not required to have a technical words. Okay. Then, though use of word trust is not needed to create a valid trust. So you may not write a word trust in that, but over there you should have a clear intention of a trust. And even though you have written word trust and clear intention is not seen, trust is not created. Okay. Terms of grant will make it clear that obligation is actually annexed to ownership of the trust property. Now, what are the essential elements of a trust deed? This may be asked. So please remember the essentials of the trust deed. The name of the author or the settler, author, settler, one and the same person. Name of trustees. Their name of beneficiaries, if any. If it is public at large, you have to write public at large. Then name of your trust. Okay, trust will be called by which name. You have to give registered office or principal place of trust. Then you have to give details of the property. Okay, so which property is going to devolve upon the trustee, the details of that should be given, like it's a 2-bedroom hall kitchen, this dimension, this much square feet, everything has to be given. So it must contain description of property sufficient to identify for purpose of the registration. After that, intention must be there to divest the trust property upon the trustee. So no language bar is there, any language, but clear words are very important. No need of technical words. Then what is the object or purpose of trust, whether it is a public trust or a private trust or a charitable trust, you have to write. Then you have to write the internal rules, regulations, like procedure for appointment, resignation, removal of the trustees, their rights, duties, powers. Then we have to define the rights, duties of the beneficiaries as well, because even they are the ultimate beneficiaries. Then if anybody want to determine the trust means close the trust. Okay, closure of the trust. Then how to close that, you need to give the procedure also for that. So this is how we create a trust. Okay, so once trust is created, once trust deed is created, we need to obtain signatures. It will be on the non-judicial stamp paper. Okay, and we need signature of settler and witnesses and trustees. We don't need signature of beneficiary over here. So who will sign? Settler, witness and trustee. Basically signature are of settler and trustees, and witness will verify that. Okay. Also their photographs and ID proof also to be furnished at the time of registration of the deed, and deed has to be witnessed by at least 2 witnesses. Settler must be signing all the pages of the trust deed. Okay. Then we have to, obviously printing of stamp paper and all, it's done before. After that signing is done. After signing is done, we have to register our trust deed. Now, where do we register? In every district or in every state, we have a registrar. In every state, we have a registrar. In every district, we have a sub-registrar. So, we have to register the deed with the sub-registrar. Okay, so we'll have to go to the office of sub-registrar. We have to pay the registration fees. We have to give required documents. What all things have to be carried? ID proof, photograph of settler, witness, along with that the trustees. Okay, so photocopy of the deed will also create or have a signature of all the trustees and also the settler. After that, whenever registration is done, okay, settler and witness have to be personally present by having their ID proof. So whenever application is given, they have to be present over there. Okay, so once the documents are vetted, it will retain the photocopy. Okay, the sub-registrar will retain a photocopy with him and original documents will be given back to the settler. Okay, and once sub-registrar is satisfied, it shall give a registration certificate. I will write that point over here. It shall grant certificate of registration. So once this certificate of registration is received, settler can apply for the PAN card. Okay, and you will get a different PAN card for your trust. Clear? This is a registration for the trust. I hope you have understood this. Now the society is also a non-profit organization. Okay, this is also a non-profit organization. You might have heard this word society for the first time, right? But in India, if we want to open NPO, that is non-profit organization, society is also one of the options available. So which act is governed the society? The act is Societies Registration Act 1860. This act governs your society. Okay, if you have heard of society called as a SOPAN, SOPAN is a society which serves the children who have autism. Okay, I just gave you one example. So when it is registered under Societies Registration Act 1860. So now what is a society? Society means it is an association of persons. Now this person have come together, they have united together by their mutual consent for serving a particular purpose. So it can be for promotion of art, science, commerce, education, protecting environment, animals. It can be any purpose. But over here the purpose of society is different. So if you want to form a society, you should have from this defined purpose only. We will go to that purpose little later. So societies are registered for promotion of charitable activities like education, art, religion, culture, music, sports, etc. And unlike the trust or Section 8 company, each state has different rules and regulations for the society. The central government has delegated the powers to the state government, and society can be registered in a particular state only. Here, even though society is registered in a particular state, but still it can be sued in anywhere in India. Clear with this? Okay. Now, what are the purposes for which society can be registered? This is important from your exam point of view, so we are going to read it. So, first, military orphan fund, that means the children who are the children of the Navy, Army, military officers and who dies, so they are orphans, so setting up funds for them, or societies which are in presidencies. Now we don't have presidencies. In British rule we had a presidencies, but now we don't have that. So military orphan funds. Then it is for promotion of any science, literature, art, instruction, or diffusing any of the useful knowledge, or it is for political education, or it is for foundation maintenance of libraries maintaining, which maintains our heritage, our culture, reading rooms, etc. for the general use, which can be open for member or it can be for the public at large, does not matter. It can also be open for public museums, galleries of paintings, other works of art, collection of natural history, mechanical, philosophical invention, instrument or design. The society can be formed for any of this, even it can be formed for education, art, literature, etc. Okay, so this is your society. Now as I told you, it is registered under government. Now let's go to what are the advantages and disadvantages of the society. The very first advantage is the formation is very easy and even registration is very simple. For formation, just we have to arrange number of members required, make rules, regulations, that is bylaws of society, and register that with the society, that is registrar of societies. We have to keep record keeping. Okay, we have to maintain records, but the requirements are very less. It is not lengthy requirements like your company. The compliance cost is also very low in comparison to the company. Our regulator, who is our regulator? You know, our regulator is registrar of societies. For section 8 company, who was a regulator? Central government, along with that ROC, right? But over here we have a registrar of society. It will be there in each state. So it is a regulator. There is a least interference of your regulator. Once if you do fraud or something fishy transaction, then only regulator will come and catch your collar. You also get various tax benefit if you are a charitable society. But if you are not a charitable society, it is only for members. It's a private society. You will not get the tax benefits. Advantages of society. Now we'll go to the disadvantages of society. What are the disadvantages? You will get tax exemption only and only if you are a charitable society or a religious society. So you should be recognized by the income tax department, only then you can get the tax exemption. Otherwise, you will not get the tax exemptions. After that, society is an inappropriate form if you want to do any commercial venture. Commercial venture means business for profit. Are we going to do business for profit in a society? No. So if anybody wants to do business for profit, it will not incorporate a society. Hence, it is an inappropriate form. In society, it is not a company, right? Only company can have a share capital. So in society, there is absence of the equity element. It cannot get listed, so it finds very difficult to raise the funds. Okay, because equity is absent. So most of the commercial investors, they don't like to invest in the society because they don't have ownership in that. Who gets the ownership? One who owns the equity. In society, whoever will be investing, either it can be a creditor or as a donation, that's it. Then over here, commercial investors regard this investment as very risky. Why? Because they think over here non-professionalism is there, malpractices may be there, fraud may be carried out. This is because they don't like to invest in the society. So they are reluctant. Now, Section 45S of your RBI Act 1934, it says that unincorporated bodies cannot accept deposits. Okay, and as per RBI Act, society is an unincorporated body. So when society is an unincorporated body, it cannot collect saving from the client. So they cannot accept the deposit from the public at large. This is also one of the disadvantages, because there will be difficulty for society to raise the fund. And also it is vulnerable to implication of money lenders act. So these are the disadvantages of your society. I hope you have understood. So going ahead, let's see whether we have to register society or not. Is registration of society compulsory. We form the society, that is a different thing. But do we need to register with the registrar of societies? We will decide this little later after looking into what are the effects of non-registration. Okay, so we will keep our answer pending. So let's see what are the effects of non-registration of society. So first effect is, under Income Tax Act, even though your society is charitable society but it is not registered, you will not get tax exemptions. Okay. So first effect, tax exemptions shall not be available for an unregistered society. Yeah, the first one. Second one talks about it will not be a separate entity. See, whenever society is formed, even though under RBI Act it is an unincorporated body, but under Income Tax Act it has a separate legal entity. But when your society is not registered, it is not a separate legal entity. So basically it does not exist in the eyes of law. So whatever property is held, property of society, okay, so trustees, ultimately trustees shall be owner of that property. What is the meaning of this? When society is not registered, it is not a separate legal entity, hence it cannot hold the property also. Society cannot hold the property. So ultimately liability will be that of a trustees. Okay, this is a second side effect. Third one, it cannot sue or be sued in its own name. So if you want to sue an unregistered society, you have to sue in the name of the trustee. So ultimately liability will be that of the trustees and not the society. After that, it cannot open bank account. Why? As it does not exist in eyes of law. It does not exist in eyes of law. So it cannot even open the bank account. These are the effects of non-registration of society. Now tell me, are you going to register the society? The answer is yes, we have to register the society. If we don't register, there is no point in opening a society, because we cannot even open a bank account. And can you do your business legally? You cannot always depend on the cash, right? And ultimately responsibility will be that of a trustee. That is too risky. Got it? Clear with this? So we have to register a society. Now there are certain important points which I want to discuss. Important points on society. The very first point, society needs to make its own charters. So it has a charter documents like your company has, memorandum of association, and instead of article it has bylaws. Bylaws contains the rules and regulations of the society. Okay, it also has something called as a governing body. Like we have a board of directors to manage the company, we have a governing body to manage the society. Okay, so it shall manage the society. Also, there are members in society. How to become member of society? By subscribing. Okay, By subscribing to its memorandum, we can become member of a society. See, subscribing always does not mean that you have to take the share. Subscribing means to sign. Subscribing means to sign. So how to become member of a society? By subscribing to the memorandum. So two different bodies are there, members and the governing body. Okay. Can members take out the profit and enjoy the profit? No, it's a non-profit organization. Don't forget that. Okay. After that, very important, remember this, it does not have share capital because it is not governed under Companies Act. It is not a company. Okay. Now the third one, it has to do annual audit. Annually it has to audit the balance sheet, P&L, and they have to appoint the auditor for that, and it is mandatory, compulsory. Okay, mandatory is the legal word for compulsory. Also, they have to convene annual general meeting of its members. Okay, once in every year. It is also compulsory. Once in every year they need to conduct annual general meeting of its members. So these were the important points about the society. Now we'll go to the formation of the society. How to form a society. Formation of the society. Now, for forming a society, we require minimum of 7 members. So, how many members are required? Minimum 7 members are required to form a society. So, you should be a group of 7 people who have a common interest. Okay, and the registration of the society will be done through registrar of societies, right? So where will be applying? Registrar of societies. So even though you are getting registered under a state, you are not getting registered centrally, okay, but still you can sue anywhere in India. Okay, after that, once these things are in place, you have to select a name. So selection of name of society is very, very important. And when you are selecting the name, even though company law is not applicable to you, still you have to take care. You have to follow rules given under Emblems and Names Act. It's very important. Plus, your society should not show any patronage to the government. That means you cannot use words like Prime Minister, President, or nation, state, unless you actually have a patronage. Okay? It should not show patronage to government. Then it should not show patronage to the government. After that, we have to draft memorandum and the bylaws. Okay, so we have to draft MOA and bylaws for the society. In this, we have to specifically mention what is the object of the society. In the memorandum, we will be writing that. In the bylaws, we will be writing about the internal rules and regulations of the society. Okay, this memorandum and bylaws we have to make in duplicate. Duplicate copy we have to make. This shall be signed by all the members. Okay, by duplicate because we file this in duplicate with the registrar of society. So original as well as duplicate both have to be signed by all the members. Okay, it has to be witnessed also. Witness anybody cannot do in this. Okay, but it should be witnessed by your notary. Notary public everybody knows. or your gazetted officer, the officer who is a government officer at the very good level, that is a gazetted officer, or even advocate can witness, or even your magistrate of first class can witness. Okay, so it cannot be witnessed by any person over here, it has to be witnessed by any one of them. Okay, so we have drafted. Now other documents which we require for the formation, we'll have to prepare a covering letter. What we have to prepare? Covering letter where all the members will sign. They will tell the registrar of society, we hereby want to form a society for this purpose. This is a covering letter. It has to be given, signed by all members, wherein they shall request formation of society. Okay, they shall request formation of the society. Okay, after that we require a principal place for society. Like your registered office, there is a principal place, so we require documents of this. Okay, then after that we have to prepare a affidavit. Affidavit who will give? Affidavit will be given by president of society, the main head. Okay, like you have a managing director or manager in a company, there is a president in society. They will give an affidavit that whatever information has been given in the application is true and correct. Okay, so anything fraud, president will be caught first. After that, if your society is already existing society and you are applying after that, so minutes of the meeting will be required, wherein your registration of society is approved. So minutes of the meeting of the society. So these are the documents along with this memorandum and rules and regulations we have to submit with registrar of society. The sixth point, all these documents, so whatever documents we made, all above documents, we have to prepare 2 sets of that. How many sets we are going to prepare? We are going to prepare 2 sets of all these documents. Okay, once we prepare 2 sets, we have to submit the documents with registrar of society. I am writing ROS, you don't write the shortcuts. You have to submit documents with registrar of society. So once it vets the documents, it shall give an acknowledgement. ROS will give us acknowledgement on one set. Okay, and another shall be retained by it, because still it has to vet it properly, right? So our application is done. Now we have to wait and watch whether we receive the certificate of registration or not. Only for companies, LLPs, we talk about certificate of incorporation. For all other, we have to say certificate of registration. If the registrar of society is satisfied, okay, it shall issue a certificate of registration. What shall issue? Certificate of registration. It shall also allot us registration number. Like we have SIN, LLP, IN for companies and LLPs. For society, they have registration number. So along with the certificate of registration, the registrar of society shall allot a registration number. Clear? Understood? So over here, your formalities for incorporation or registration is over. Okay. So once your society is registered, once you receive a certificate of registration, you may open a bank account. Once bank account is open, will society automatically get all the exemption? The answer is no. Society will not get all the exemptions automatically, but they have to apply for that. Okay, so till now we're not done with the process. Registration is over, but now we have to obtain registration with the income tax. So the now next one, formalities to avail tax exemptions. What we have to avail? Now we have to avail a tax exemption, so we are going to check out the formalities. First one, so once the societies are registered, it has to register under Income Tax Act also. So societies has to register under section 12A or 12AA. I hope you remember section 12 of Income Tax Act. Various tax exemptions were given, right? So tax exemption will be only given to the charitable society. So whatever income is earned on that charitable society will be tax exempted if society avails registration under 12A or 12AA of Income Tax Act. (1961). Clear? So for claiming the tax exemption, they need to register with whom? With the Income Tax Act under section 12A or 12AA. Now this registration of 12A, 12AA is a one-time registration. So it's a one-time registration. It will be valid till the lifetime of the society. So till the time society is there, it can avail the exemption. Just a one-time exemption they need to avail, the 12A or 12AA. Clear with this? Understood? You can make a note of it. After that, if society wants that whatever donations are received, the donor should also get the exemption, it needs to apply to the income tax cost. Okay, so donations, we will write this. If donor wants to avail rebate, okay, on donations given to the society, so for that what society has to do? Society shall take approval, okay, under section 80G of Income Tax Act. What society has to do? It has to first take approval under 80G, then only society can issue a certificate under 80G and the donor shall get the exemption. Without that, donor will not get the exemption. Clear, guys? Understood? So we are done with this chapter. Okay, I want to ask few questions relevant from the exam point of view. Can foreigner be member of society? Can a foreigner be member of the society? The answer is yes. Foreigners can invest and form a society, no problem at all. Foreigners are allowed to invest in society, no problem. Okay, now I hope you have understood your chapter number 7. Wasn't it interesting chapter? Yes, you learned so many new concepts like Section 8 company, other non-profit organizations like society and a trust. So now let's quickly discuss the questions. First, now we are going to discuss question which you have to solve. So we'll be just doing discussion, and the past paper question we shall be looking into the answers as well. Okay, so the first one, Miss Hitakshi along with her 10 friends desires to incorporate a company not for profit. Okay, so Hitakshi wants to start a non-profit company for protection of ecosystem as permissible under Companies Act. as a PCS advisor on procedural aspect for formation and incorporation of the company. So straightforward question it is, you have to advise as a practicing CS how to incorporate a Section 8 company, also the procedure of the same. Okay, so documentation, filing of the form, everything needs to be guided. I hope it is clear. After that, the next one, a group of persons, including two foreigners, wish to form a society and seeks your advice on purpose for which society can be formed under provisions of Societies Registration Act 1860. I hope you remember we had learnt what all purposes we can form a society. Okay, like charitable, then orphan funds for military children, all those are the purpose. Okay, then advice on procedure. So they are asking us two things. Okay, how many things they are asking us? They are asking us two things. First one is purpose and second one is the procedure. So two answers you have to write. I hope it is very clear. By now I think you have understood how to make out what is asked in a paper. If you make out this, 25% of your work is done. Okay. After that, who can create trust and who may be a trustee? So these two things you have to answer. What is the first question? Who can create trust? Straightforward question it is. And who may be a trustee? Both of them are straightforward. Great. After that, advise Miss Neha who wish to form a trust for which about income that are excluded from computation of taxable income of trust or society are as follows. So I had taught you section 10, 11, 12, 13, right? So all these sections you have to give the elaboration over here. Such straightforward questions are not asked in your exam, but if at all they are asked, those are the jackpot questions for you. Okay, now let's see your past paper questions. So the first one, Murthy wants to form a society to promote Beti Bachao Beti Padhao movement of Government of India. He seeks your advice on the following. Okay. Of Government of India, he seeks your advice on the following. So first of all, what he is asking advice? Purpose for which societies can be formed. So again they are asking for the purpose. Guys, please do the purpose very carefully. Okay, I had given 2 stars for that whenever we were learning that. Whether foreigners and other registered societies can be members of society, the answer is yes. Okay, foreigners can be the members of the society, no problem. After that, next question, yes, we will see the answer first. Murthy, who intends to promote Beti Bachao Beti Padhao, can be advised as answer. So this is how you have to write the answer. As per section 20 of Societies Registration Act, your society can be formed for charitable, military orphan funds, for promotion of science, literature, arts, diffusion of useful knowledge, political education, foundation of maintenance of libraries, reading rooms open for public museums, galleries of painting, etc. So these are the purpose. Then next question. Yes, a society can be created by 7 or more person. Apart from person in India, even foreigners are allowed and even registered society can be member of society. So these people can subscribe to the bylaws and memorandum of the society, thereby become the member. I hope you understood how to write the answer. After that, a company under Section 8 can be registered as a small company under provisions of Companies Act. What do you think? Can Section 8 company be a small company? The answer is no. This we have already learned in chapter number 4 in definition of a small company. We have read that small company can never be a Section 8 company. I hope you understood. Okay. So, Section 2 clause 85, that is the definition of small company, states that it is small company other than public company whose paid up does not exceed 2 crore and whose turnover does not exceed 20 crores, right? But nothing shall apply to following. So your small company cannot be holding subsidiary, it cannot be section 8, it cannot be a statutory company as well. Hence, as per the above provisions, a section 8 company cannot be treated as a small company. I hope this is very clear. Great. Now, the next question, what are the tax exemptions available to the private trust? Straightforward questions it is. You have to write about section number 10, 11. But remember guys, they are asking about a private trust over here. So when they are asking about private trust, will you write about the public trust? No. So what are you going to write about the two different trusts, that is discretionary trust and a non-discretionary. In discretionary, what happens? Income is taxable in whose hands? It is taxable in the hands of trust. And non-discretionary, it is taxable in hands of the beneficiaries. I hope this is very clear. Great. Then can trust do any other kind of business apart from the property? The answer is no, cannot. If they do, they shall be liable to pay maximum marginal rate. Clear? So that's all guys. We have done with the chapter 7. Let's start with our chapter number 8. I hope you have done with your 7 chapters very nicely and you are also solving the case laws, because writing practice and solving the case laws are equally important. So once you are done with the chapter, try to write few notes on that, because many of the students lag in writing and then they say, ma'am, even though we are preparing perfectly, still we are not getting good marks in exam or we are not able to clear. The reason behind not clearing is not writing practice. Also, you don't have experience of cracking or solving the case laws. So I hope you are doing it nicely. So without wasting our time, let's start with our chapter number 8. Our chapter number 8 talks about the financial services organization. So organization which provides financial services. So when we talk about the financial services, first thing which come into our mind are banks, right? But we are not learning about banks over here, but we are learning about NBFCs over here, that is non-banking financial organizations. So this entire chapter is about an NBFC, which is an alternative to your banks. So if any of the entrepreneur want to start with the NBFC, what all requirements are there for starting or incorporation of NBFC? Also, what are the types of NBFC? Who is the regulating authority? What are the rules regulation important for the NBFC? Also, at last we'll be learning about the payment banks. So this is the total agenda of this particular chapter. Believe me, it's an interesting chapter and very new thing which you are going to learn over here. So let's begin. So as I told you, the name of this chapter is Financial Services Organization and the registration process. Now, weightage is about 7 to 8 marks. Okay. Sometimes they ask you 2 to 3 questions from this. Sometimes they ask you 1 question for this. So part A, basically we cannot predict how much and from which chapter will come. But definitely when we'll go to part B and part C, I can tell you for how many marks this chapter can come. But for part A it's difficult, so entire part A has to be done very nicely, because it consists of heavy weightage, that is 40 marks. So without wasting time, let's go and start with our chapter number 8. So in this chapter, as I told you, we are going to learn about the Financial Services Organization. So before beginning that, when we think about the financial sector or financial service sector, in India, there are various kinds of organizations, various kinds of companies. So what is a financial sector basically? Banks provide us financial sector services, giving loan, taking loan, Okay, lending and borrowing, main function of the banks. Then one more sector we have is an insurance sector. Okay, even insurance is a financial services provided by the insurance companies. After that, we have mutual funds. Even this is a financial services sector. We have pension, etc. So many financial service sectors are there. So all this lending, borrowing, insurance, etc., are done by the banks earlier. Okay, so only banks were there earlier. That's why banks are very famous, right? They are very old. But think about the population of India. Out of the total population, at least 30 to 40% wants to do their own business, or they require the funds. Businessmen are 30-40%, but 90% of the population requires loan for one or the other thing. Everybody goes to the bank. Do you think banks are sufficient? No. So they are insufficient and they have lot of pressure on banks. There is lot of pressure, even though there are two kinds of bank. We have private sectors bank also, we have public banks also, but still they are insufficient. You can count the number of banks and then look into a population. So they are insufficient. So there was a need of someone who can do the same kind of business but which is not a bank. Why it is not a bank? Because bank has to follow the banking regulations. Bank has to follow which law? Banks has to follow Banking Regulation Act. And Banking Regulation Act, it provides very stricter compliances. That's why lot of pressure is there. They have to maintain the liquidity ratio. So many things are there. So there was a need of some alternative to bank which will not have such stricter compliances, and the need of money by the entrepreneurs can be done easily. Okay, so that is a reason where our government of India, okay, they thought about an institution called as an NBFC, which is non-banking financial company. It is a non-banking financial company. Now the name itself says it's a non-banking. It is not a bank. Okay, it is not a bank. Then which law is applicable to the NBFC? It is not a bank. It's a non-banking, but still it is providing you the financial services. We will see the definition of financial services. So whatever services are provided by the bank, same services will be provided with the non-banking financial company, right? The government of India came up with this alternative. Now how it is different we are going to see, but first we have understood that it is not a bank, correct? So which law is applicable and who is the regulating authority? The law which is applicable is RBI Act 1934. So to NBFC, Banking Regulation Act is not applicable. But which law is applicable? RBI Act 1934 is applicable. Very clear with this? I hope it is clear. Great. So we have understood till now it is not a bank. RBI Act 1934 is applicable. And who is a regulator of NBFC? Regulator of NBFC, same. So whoever is a regulator of your bank, same is a regulator of your NBFC, that is our RBI. So NBFCs are regulated and governed by your RBI. Along with the RBI, just look into this word NBFC. The last word is a company. It's a company. So which law is applicable? Along with the RBI Act, Companies Act 2013 shall also be applicable. Okay. And who is the other regulator? MCA. But who is the main regulator? RBI. Clear? To sum up, NBFC is not a bank, but it provides for the financial services. It is governed by RBI Act 1934. Who is the regulator? RBI. Since it is a company, they also have to follow Companies Act 2013, and they also have the regulator called as a MCA. So they will be filing all the forms with the ROC, same like our private public companies. Okay. Even the NBFCs can be either a private company or a public company. That's why we call private public OPC as base. Clear? Understood? You can take the screenshot of this, or you can write down this and pause the video and note it down, no problem. Okay, so I hope you have understood what is an NBFC and what are we going to learn. So let's go to the next one. Now, why this NBFC have come, I have told you. To reduce the burden on the banks, they require an alternative who can carry out same functions like the bank, but they don't have stricter compliance like your NBFC. That does not mean that NBFCs are free. The regulator is sitting on their head, RBI. Wherever money related matter comes, be it a FEMA, be it a bank, be it any law relating to money, RBI will always be there. Okay, and RBI is not at all lenient. It's very strict. So though banking regulations are not applicable, NBFCs have to follow stricter compliance. Okay, you might have heard about Bajaj Finance, Bajaj FinReserve. These all are the examples of your NBFCs. I hope it is clear. Now going on to the next. What is the difference between the banks and NBFC? We are going to write a difference between bank and a NBFC, and then we will write why do we go to a NBFC other than bank, because whenever we need a loan, we'll always think about a bank. But if NBFC is providing us with the same loan, that too with less rate of interest, don't you think we will go to the NBFC? Yes. So NBFC and banks are tough competitors now. Okay, both of them try to compete with each other, keep the consumer friendly products, and this is how our economy is growing as a whole. Okay, so I hope it is very clear. So now let's see what is the difference between the bank and an NBFC. First of all, which law is applicable? To bank, we have a Banking Regulations Act. (1949), and to NBFC we have RBI Act 1930. It's the first point of difference. Second point of difference, bank can accept demand deposits. Bank can accept demand deposits. What is demand deposits? I have an account with the HDFC Bank. In that 1 lakh rupees is there in my account. Anytime I can withdraw that. Yes, I am in need of money. I can swipe my credit card. I can swipe my debit card. I can go for shopping. Net banking can be done. Any point of time I can withdraw that 1 lakh rupees. Yes, that is demand deposits. I can draw check on the HDFC Bank. The answer is yes. but same is not possible for your NBFC. So NBFCs cannot accept demand deposits. They cannot accept demand deposit, means there's always a maturity period. So if I keep 1 lakh rupees with the NBFC, I have to keep it as fixed deposit, recurring deposit, and I can withdraw it only after a certain period. Okay, so it does not accept the demand deposit because it is not a bank, right? I hope you understood. We cannot draw checks on NBFCs like your banks. So this is the second point of distinction. Now the third one, banks are part of payment and settlement system. Okay, banks are part of payment and settlement system. Now what is this? You want to pay electricity bill and you have 1 lakh rupees in your bank account. Don't you draw a check on HDFC Bank? Yes, we do. So what we are doing? We are directing our HDFC Bank to pay our electricity bill? Answer is yes. You want to pay some creditor. So you are drawing check on HDFC Bank, ordering HDFC Bank to pay so and so amount to your creditor. This is payment and settlement system. Okay, so HDFC Bank or any other bank can be a part of payment and settlement system. So you can order your bank to pay on behalf of you to some person if you are having money in your bank account. But this is not possible in NBFCs. So NBFCs are not part of payment and settlement system. Why they are not part of payment and settlement system? Because you are keeping deposits with them. If you have deposited 2 lakh rupees with Bajaj Finance and you order, can you order Bajaj Finance, please pay my creditor 1 lakh rupees? No, you cannot draw checks on them. How are you going to order them? It's not possible. You have to withdraw your money from there and you have to pay to the creditor. I hope it is clear. Clear? Great. So this was the second point of distinction. Now we'll go to the fourth one. Banks provide for deposit insurance and also for credit guarantee. Banks can give credit guarantee on behalf of you, but this is not done by any of the NBFCs. Banks also provide for the deposit insurance. Suppose you are having 5 lakh rupees deposit with the bank. Something happens to the bank. You have insurance. So you can get that amount of insurance. But your NBFCs cannot give deposit insurance. They do not provide for deposit insurance or credit guarantee. They cannot give you credit guarantee also. They also don't provide for the deposit insurance. So if something happens to Bajaj Finance and you have deposit of 5 lakh over there, you don't have anything in your hand. Clear with this? So this is the distinction between the banks and the NBFC. The first point was regulated law. Second point, demand deposits are accepted by the bank but not by NBFCs. Third point, bank is a part of payment and settlement system. NBFC is not part of that. Fourth point, banks provide for deposit insurance and a credit guarantee, but NBFCs don't provide for deposit insurance and the credit guarantee. So I hope till now you have understood what is a bank and what is an NBFC. Okay. Now let's start with an NBFCs. Okay. So let's go to the definition of NBFC, what actually NBFCs can do and what NBFCs cannot do. This is very important. Okay, because any organization which is doing financial services, which is giving financial services, cannot do the non-financial services. So there are certain businesses which NBFC can do and NBFCs cannot do. So let's start with that. What all business NBFCs can do? NBFCs can carry out business of lending and borrowing funds. So what your bank does, right? Giving and taking loans, that can be done by NBFCs because it is one of the financial services. Also, it can deal in investments. What is investment? Buy and sell of securities, right? So we have seen about the investment company. What is an investment company? All the investment companies are your NBFCs because their main business is buying and selling of the securities. They don't have any other business. This is also a financial services. Okay, so investment is also a financial services which NBFCs can carry out. After that, leasing. Leasing finance can be done by your NBFC. Giving on rent, the finances can be done by your NBFCs. Even this is a financial services. Then we have as a hire purchase. Hire purchase is also a financial services. You want to buy a car, you don't have enough money for that. Okay, so you take a loan from NBFC. So you are enjoying the possession of the car, but at the end of the loan period, if you are not able to pay off that money, the car goes to the NBFC. This is the hire purchase. Hire purchase is very famous for purchasing car, tractors, vehicles, trucks, etc., etc. Okay, so that is a hire purchase. This service can be provided by your NBFC, no problem. After that, insurance services. All your insurance companies are your NBFCs. It can be banks also, no problem at all. Okay. After that, it can also do chit fund business. Chit fund business is nothing but collecting small savings from the people, investing them in particular securities and giving them return. That is a chit fund. So these are the business allowed to be done by NBFCs. This all amounts to your financial business. All these things are done by the banks also. But I told you NBFC is an alternative to it, right? So when NBFCs can do all this kind of a business. Now there are certain business which NBFCs are not allowed to do. All this amounts to financial business. Okay. Now there are certain business which NBFCs are not allowed to do. Now which are those business? We will write it as a prohibitions. NBFCs are prohibited from doing this kind of businesses. Now what kind of business it is? The first one is an agriculture activity. So NBFC cannot carry out agriculture activity. It's not allowed at all. Why it's not allowed? It's a non-financial services. So it cannot do it. Simple. Right? After that, the second is any of the industrial activity. It cannot carry out industrial activity also. Production. It's a non-financial services. Cannot be done by NBFC. But financing can be done by that. Understood? After that, purchase or sale of goods. It cannot do purchase or sale of goods. One exception lies over here. Which exception? Even your shares are goods, right? So except of shares, They cannot deal in purchase or sale of any of the goods. They cannot produce also, they cannot purchase or sale also, because it's a non-financial service. After that, they cannot provide for other services. Okay, they cannot provide for other services, not allowed. Only financial services they can do. Apart from financial services, they cannot carry out any other services. Last prohibition, they cannot deal in real estate products also. They cannot deal in buy or sale of real estate products. Some people do, no, buying and selling of flats. This cannot be done by your NBFC because it's a non-financial services. Okay, this is very important, very important to understand the NBFC. What NBFCs can do, what NBFCs cannot do. You can note down, you can revise, you have to by heart this. Okay, this can come in the form of case law or direct definition can be. Clear with this? Great. Now let's go to the next one. Now as we are looking at the financial services, right? So there are certain requirements of NBFCs. Any company who is doing financial services can be NBFC, that is true. But what is financial services? We saw the financial services, that is true and correct. Just imagine a company is doing investment. Okay, it is putting 90% of asset in the production and 10% of asset in the investment. Do you think it's an investment company? The answer is no. So we saw the activities. Now we are going to see one test. It is test for financial services. It is test for what? It is test for financial services. So even though you are carrying out lending, borrowing, insurance, chit fund, etc., still you have to pass this test. Then only you will be called that you are doing a financial service, and then you will be called as an NBFC. So one requirement of NBFC is your financial services. So without passing this test, no company can be an NBFC. Now which test is this? The test is called as 50-50 test. Very important test it is. Which test is this? It is called as an 50-50 test. Now what is this 50-50 test? Let's understand this. Okay, let's understand this. Now this is an NBFC. ABC Limited is an NBFC. Now out of the total assets of ABC, okay, out of the total asset of ABC, more than 50% of the asset should be in financial activity, or it should be financial asset. Okay, so out of the total assets of your NBFC, at least or more than 50% of asset should be the financial assets. Now what are the financial assets? Have anybody seen the balance sheet? In the balance sheet, on the asset side, you have debtors, sundry debtors, right? They are the financial asset because you have given loan to them, so it is receivable, right? Then one more, you have investments, even that is your asset. You have advances, that is your assets. Okay, so these are called as a financial asset. So out of the total asset, more than 50% asset should be financial asset. Clear with this? Then you can say you are doing a financial activity. This is the first 50. Okay, this is your first 50. Now we are going to the second 50. And out of your total income, more than 50% of your gross income, I will write it here so it will be very easy for you. Out of your total income, more than 50% of the gross income of your ABC Limited. Okay, more than 50% of the gross income of your ABC Limited should come from these financial assets. Now, how income comes from the financial assets? If you have debtors, you will get your principal amount that is different, but they will pay you interest. Yes. If you have invested somewhere, they will give you profits, they will give you dividend, so profit or a dividend. If you have given the advances, if you have leased somewhere your property, you will get the rent. So all this should be more than 50% of your gross profit. This is your 50-50 test. Let's revise it one more time. Okay, just look into the diagram, you will understand it clearly. Whenever any company wants to be an NBFC, more than 50% of its assets should be financial assets. Okay, so financial assets are debtors, advances, investments, etc. Okay, you can call it insurance also. And out of that, you should earn more than 50% of your gross income. So whatever are your financial assets, that income should come more than 50% of your gross income. So example, ABC Limited gross income is 1000 rupees. I am just taking an example. So at least 501, that is more than 50%, right? 501 should come from your financial asset. Then only you call it as an 50-50 test pass, that is an NBFC. So one requirement of NBFC was 50-50 test. Clear with this? Understood? Please understand this. You need to know these wordings very clearly. So this was the first requirement of financial services. After that, second requirement talks about we require a license from RBI. What do we require? License from RBI. So any person, any entrepreneur wants to incorporate an NBFC, the first step it will do is incorporate the company under Companies Act 2013, right? The same procedure which we saw. And the second step they will do, obtain license from RBI. Okay, so after company is incorporated, you will be obtaining license from the RBI for starting business of NBFC. Clear with this? This is the second requirement. Now there are certain exceptions to this rule. Exceptions to rule of obtaining license. Certain kind of NBFCs don't require license from RBI. Okay, certain kind of NBFC don't require license from the RBI. So from where they'll be requiring license, this depends on the type of NBFC. So we'll make a table, type of NBFC and license requirement. The first kind of NBFC we have is a housing finance company. Housing finance company. This housing finance company don't require license from RBI, but they will require license from NHB, that is National Housing Bank. Okay, so housing finance company, even though it's a NBFC, it will not require license from RBI, but they will require license from the NHB, because NHB is a regulating authority for housing finance companies. The next one we have the merchant banking company or venture capital. These companies, they don't require license from RBI even though they are NBFCs, but they will require license from the SEBI. So they will be registered with the SEBI, that is Securities Exchange Board of India. The next kind of NBFC is a Nidhi company. We have seen what is a Nidhi company, right? Everybody know. Did I ever mention you have to take license from RBI? No. RBI has exempted Nidhi company even though it's an NBFC. Why it is exempted? Because it operates within the members only. Can Nidhi company give loan to the outsider? No. Can they accept loan from the outsider? No. Okay, so who is the regulator of Nidhi company? Only MCA. So Nidhi company don't need to obtain any license even though it's an NBFC. It's an exempted category company. After that, we have a chit fund company. Chit fund company is also an NBFC, but still it does not require RBI license. It will require license from the state government. Okay, so authority is given to the state government. The next one is an insurance company. So those companies which are NBFCs dealing in the insurance company will not obtain license from RBI, rather they will obtain license from IRDA. You have heard of IRDA? Insurance Regulatory Development Authority of India. So license for insurance is required by IRDA. Clear with this? Everybody understood? So this is the exception to the rule of obtaining license. What is the main rule? NBFC requirement is 50-50 test. Second, obtain license from RBI. Certain NBFCs don't require license from RBI. So which are those NBFCs? A Sept housing finance company from NHB, merchant banking from SEBI, chit from state government, insurance from IRDA. Nidhi companies are exempted, only it is regulated by your MCA. Clear with this? So we have seen these two requirements. First is 50-50. Second one is license from RBI. Now we are going to the third requirement. The third requirement says that it requires minimum of net owned funds. There is a requirement of minimum net owned funds. So every NBFC requires minimum net owned funds of rupees 2 crore. So 2 crore is a basic net owned fund required to incorporate any NBFC. What does this mean? The authorized share capital of any NBFC cannot be below 2 crore rupees. Why? Because minimum net owned fund required is 2 crore rupees. I hope this is very clear. Great. Please revise this because I think you are learning this for the first time. Okay. So that's it for this video. In the next video, we shall see what are the NBFCs and its types. Okay. NBFCs we have seen. Now we will go to the types of NBFCs. Chalo. So I hope you have understood what is NBFC. I hope you have understood what are the requirements of NBFC. 50-50 test. license requirements, and minimum net owned funds. Now, as far as types of NBFCs are concerned, broadly your NBFCs are divided into three categories. The first category is deposit taking NBFCs. Okay, deposit taking NBFCs. The second category is non-deposit taking NBFCs. Non-deposit taking NBFCs. And the third category we have, it will be dependent upon the type of activity what they are doing. Okay, so what is a deposit taking NBFC? Deposit taking NBFC means it will accept deposit from the public at large. Okay, so basically they can borrow money from the public at large, is called as a deposit taking NBFC. Non-deposit taking NBFCs means these NBFCs will be prohibited from taking deposit from the public at large. They may be allowed to take deposit from its members. Any other type of activity, we are going to learn this in detail now in this video itself. So the activity they do, like one NBFC is doing investment, so it will be called as an investment NBFC. One NBFC is doing insurance business, it will be called as an insurance NBFC. So on the type of activity your NBFC will be defined. Okay, so this is a broad classification. Now of these three, okay, it can be further divided into two categories. Some may be systematically important. Some may be systematically important and few will be non-systematically important. So some are systematically important and some are non-systematically important. Now what is the meaning of this? Systematically important means it has so big a set that it may hamper our economy. So if the systematically important NBFC or any NBFC, good results have come or profits are huge, it is going to affect our economy. So who can affect the economy? Who has huge asset? So any NBFC which affects our economy or have effect on the economy will be called as a systematically important NBFC. So this systematically important have big asset size. Okay, and because of this they have effect on our economy. What about non-systematically important? They don't have big asset size, so they not have effect on our economy. They don't have any effect on the economy. They are small NBFCs. Okay, so systematically important means they will be having effect on our economy, and systematically, non-systematically important means which is not having any effect on the economy. Now to write this in your notes, in your module, you might have seen some words, they uses some letters to write. So suppose there is any NBFCs which is non-deposit taking systematically important. How do you write it? We write it like this: NBFC hyphen NBFC hyphen non-deposit taking systematically important. This is how we write. So NBFC non-deposit systematically important. If it is not systematically important, then how do we write? NBFC non-deposit taking. Okay, so this is just for your knowledge. So I hope you have understood the broad classification: deposit taking, non-deposit, and on the type of activity, further divided into systematically important and non-systematically important. So now let's start with the third one. I had told you we are going to learn this in detail in this video. So let's start with the first one. On the type of activity, it can be classified as follows. The first one is asset finance company. Which one is the first one? Asset finance company. Now what is a asset finance company? It is that kind of an NBFC, okay, which helps in financing the asset. So if there is a production industry always is in need of huge machineries and all. So do they have so much of finance? No. There will always be requirement of a loan. So asset finance NBFC will give them loan to purchase the machineries. That's why it is called as the asset finance company. So this asset finance NBFC shall be financing the purchase of the machineries required for the industrial production. It itself is not doing industrial production, please remember, but it is financing those industries which require loan to purchase the machineries. That is called as an asset finance company. It is that kind of an NBFC which is not carrying on any of the industrial activity. Can NBFC carry out industrial activity? No. Okay, but it finances the asset required for industrial activity. So what it is doing? It is financing the asset required for the financial activity. I hope you have understood. I'll explain you one more time with the help of an example. There is a AFC, that is asset finance company, don't forget. And this is an industrial company or industrial enterprise. This industrial enterprise want to purchase the machineries. Okay, they want to purchase the machineries worth rupees 10 crore. Now they went to AFC for loan of rupees 10 crore. So AFC shall grant them loan of rupees 10 crore. Why this 10 crore rupees is asked? It is for purchase of the machineries. So is your AFC doing production activity? No. It is financing the asset of the industrial activity. Can it finance any asset? No. Only and only such asset which helps in the manufacturing activity. That's it. That's why it is called as a asset finance company. Now I hope you have understood what is the AFC. Now we are going to see the requirement of AFC. The requirement is, first, what is the principal business? The principal business of such AFC shall be financing the asset, right? So it is financing the asset required for manufacturing activity, right? For the manufacturing activity. The second requirement is a test. What is the test for NBFC? Everybody remembers 50-50 test. But for AFC, at least 60% of its asset should be, I cannot write it as a loan, but we can write it as financing for manufacturing activity. Okay, so out of its total asset, at least 60% of its asset are gone to the industry as a loan. So they have provided their asset, that is asset. What is an asset? With which you do a business, right? Your asset. So there is a money. What is your main business? Giving loan for the financial activity. So at least 60% of asset is occupied in your loan, which you have given to the industrial enterprise to purchase the machine. Clear with this? And another 60% about your income. Minimum 60% income should come from these financial activities. Clear? So over here the requirement is 60-60 instead of 50-50. Got it? So this is your asset finance company. You can just note down, or even you can take screenshot, or you can write by pausing the video, no problem. Okay, so let's go ahead now. The second type of NBFC is an investment NBFC. Investment NBFC means what? The main business will be purchase and sale of the securities. So how they will earn the income? Wherever they are doing investment, they may receive dividend, yes. And whenever they sell that investment, okay, if the market is good, if the price is good, they may earn profit also. So their main business will be their principal business is acquisition of securities. What is the principal business? The acquisition of the security. I hope it is clear. Okay, only this much you have to remember. Now third type of NBFC is a loan company or a loan NBFC. Now loan NBFC means what? It will give loan for any kind of purpose. It can be personal, it can be business loan, it can be loan for durables like for purchasing AC, fridge. Now people purchase mobiles also on loan, right? They want the best mobile phone, even though they have to take it on loan, no problem. So any kind of durables you require, you can take a loan. This company, this NBFC will be providing loan for any kind of thing, be it a personal loan, business loan, durable loan, any kind of a loan. Okay, but very important thing to remember, but it is not an asset finance company, because asset finance company only finances the asset, and this loan NBFC can finance any purpose. Clear with this? Understood? Now going to the fourth one. Infrastructure finance NBFC. What is infrastructure? Infrastructure means roads, malls, bridges, right? Amusement park. This all are your infrastructure which is required for living. Residential complexes, connectivity, all these are the infrastructure. They are huge projects, right? So huge project require huge funds. Okay, this infrastructure company, what it does, please mind this word over here, it's an infrastructure finance company. Which company is this? It's an infrastructure finance company. You can also call it as an NBFC. But one word has to be remembered always. It itself is not going to do infrastructure business. It is not itself going to do construction of roads or buildings and all. It is just going to finance. What are they going to do? They are just going to finance. Okay. So these infrastructure NBFC, they shall finance the infrastructure project. What they shall do? They shall invest or finance the infrastructure project. So there is any company which is going to build roads. Okay, they have got a government contract. For that they require 500 crores of loan. Our infrastructure NBFC can finance them. So this is called as the infrastructure finance. Clear with this? Understood? Now, there are certain requirements. Okay, we have to remember this. Requirements of, I am writing short form, Infrastructure Finance Company, IFC. The first requirement is about the 75% of asset of your IFC should be financing of infrastructure project. Okay, this is same like AFC. In AFC we require 60% of the loans to be given to the manufacturing activity. Over here instead of 60% we require 75%. So 75% of your loan should be given to whom? The infrastructure companies for developing the infrastructure projects. The first requirement. The second requirement talks about its minimum net owned funds, as it is huge company. Why it is huge? Because it needs to do big loans, right? For infrastructure, do you think they will take 1 crore, 2 crore loan? No, minimum 500 to 1000 crore of loan is required. So net owned fund should be minimum of 300 crores. How much is requirement? 300 crores minimum net owned funds requirement of IFC. The third requirement, we have something called as a credit rating. Credit rating means we have various credit rating agency like ICRA. Okay, we have CIBL. This will give rating to your institution. How are you? Are you complying with the compliances, your projects, your loan giving, taking, your default, everything taken into consideration? They will give you rating. You are A plus, B, C, D. How are you? Okay, so minimum credit rating required for IFC is A. Which category we require? A category. The last one is they have to maintain something called as CRAR. What is CRAR? CRAR is nothing but capital to risk weighted average. Okay, means 100 rupees is your capital, how much loan you can give, how much risk you can take. So they have to maintain CRAR of at least 15%. How much? 15% CRAR. So this is your infrastructure finance company and the requirement of your infrastructure finance company. What is the infrastructure finance company? It finances the infrastructure projects. Does they carry out the infrastructure project? The answer is no. They just do the infrastructure project finances. there are 4 requirements. 75% of asset should be in loan given to infrastructure project. Minimum net on funds 300 crores. Credit rating A. CRAR 10%. So this is your IFs. After this, the next one. Now fifth one we have is, listen to this name, systematically important core investment company. What is the name of this company? Systematically important core investment company. Okay. In credentials, how do you write it? We'll write it like this. CIC, that is core investment company, and which is systematically important. How do you write it? Core investment company which is systematically important. Now you have to look at this word core. So the main business, the core business of this company will only and only be the investment and not any other thing. So what is the difference between the investment company and this? I will tell you what is the difference. Okay, and this is systematically important also, so huge asset size it will have. So there are certain conditions or requirements of this systematically important core investment company. What are those? Very first one, out of its total assets, okay, out of its total assets, at least 90% of its asset should be investment. Okay, so out of its total assets, 90% should be investment. Investment means what? Equity, pref, that's it, investment. Okay, so please highlight the word 90%. So 90% will be their investment, total asset. Now, out of this 90%, second requirement says that out of the 90%, at least 60% investment should be in the following. So where should be the 60% of investment? In equity. 60% investment should be in the equity or any instrument which is convertible, or convertible instrument into equity. It is convertible within 10 years from issue. Okay, so out of the total asset, 90% should be investment, neither equity or pref. But out of that 90% also, 60% should go in equity or any instrument which is convertible into equity within 10 years of issue. These are the first two requirements. After that, third one, can they give loan? Can they issue debentures? Loan or debt instrument. Loan or debt can be only given to the group companies. Okay, so loan or debt can be only given to the group companies. Now what is a group company? Group company means where they are having equity investment. So where there is equity investment, only there they can issue the debt instruments. They can subscribe to the debt instruments and also give the loan to only and only group companies, because it is not a debt company or a loan company. Please remember, this was the next requirement. The fourth one says they are not allowed to trade in the stock market. Now you'll say, if they are not allowed to trade, how are they going to do investment? They have to do the block deals. So what is allowed? only block deal. They will sit with the promoters of the company. Whenever they like, they can enter into a block deal. Huge sell stocks will be bought, and at the same time, after 2 to 3 days, they cannot sell off. They have to maintain them as an investment for 6 months, 1 year, or 2 years. After that only they can invest. So only block deal is allowed, and when they want to sell, selling only in case of a disinvestments. They cannot do trading, because if they trade, what will happen? They will buy 1 lakh share, 50,000 shares. Don't you think there will be sudden spikes in the share price? So that's why it's not allowed to trade. Next one. Apart from this investment, it cannot carry out any other financial activity. It cannot carry out any other financial activity. It cannot carry out. Okay. After that, their asset size minimum should be of 100 crores. So asset size requirement is 100 crores, and they can accept funds from the public. Can accept deposits from public, no problem. But yes, there are certain non-deposit taking core investment companies also where they cannot accept the public fund. Okay, so this is your systematically important core investment company. I hope you have understood. You can go through these notes, no problem. After that, let's go to the next one. Sixth kind of an NBFC. I know all of this cannot be remembered at one go, right? So what you can do, you can read it for 3 to 4 times, and then it will be easily, remembered. The basic is you have to remember the concept. Like if it is an IFC, what is an IFC? What is the requirement? If it is a systematically important core investment company, and what is systematically important? What is an investment company? And in that, what is a core? So in this way, you can remember it. So after that, we'll go to the next one, which is an infrastructure debt fund company or infrastructure debt fund NBFC. Over here, we have to remember the word infrastructure. So now I hope you have understood that infrastructure means what? This is that kind of an NBFC which will be financing the infrastructure projects, and now this is a debt fund NBFC. So these debt fund NBFC, it will be raising fund from the public. What they will do? They will raise fund from the public by issuing debt bonds. So how is the arrangement? I'll explain you that first. Listen to this very carefully. There is IDFC, that is Infrastructure Debt Fund Company. Okay. Now, there is an infrastructure company also. So this infrastructure company deals in infrastructure. So now this company approached IDFC for loan of 100 crores. How much is their loan requirement? 100 crores. So this IDFC, what they will do? They will issue bonds. Okay, they will issue bonds. Where they will issue bonds? In the open market, or they can also do the private placement, no problem. What is private placement? You will be learning in your company law. So they will issue bonds to the public at large or to one particular group of people. Okay, this public will subscribe to these bonds and give money. So this money will be given to the IDFC. IDFC shall finance infrastructure company. So 100 crore is not given from the pocket of IDFC, but they will issue bonds, raise money from the public and then finance the infrastructure company. So whenever infrastructure company shall pay off the loan of 100 crore rupees, same shall be paid back to the public. And between whatever they receive as a commission, as an interest, that will be the income of the IDFC. In case of default, then they have to bear the consequences. So infrastructure debt fund company raises fund from the public at large in order to finance the infrastructure company. I hope you understood this. Now there are certain requirement of these bonds. Now these bonds, minimum maturity of these bonds shall be of 5 years. Why minimum maturity is 5 years? Because it is about the infrastructure project. It takes long time to complete. That's why minimum 5 years maturity is there. And this bond can be either in the rupee denominated or it can be a dollar denominated. Now what is this? If IDFC want to finance an Indian company, it will raise bonds in Indian rupees only because Indian rupees need to be transferred, right, given loan. But if this IDFC want to give loan to the foreign company which is in USA, so they will raise bonds of dollar denominated. So they will be raising dollars because same has to be paid to the foreign company. I hope it is understood. So bonds can be either rupee denominated or a dollar denominated, even same like your ECBs. Clear with this? Understood? Very important thing. This debt bonds can be only issued by your IDFC and not by any other NBFCs if they are not allowed to do so. Okay, this is clear. We will write that point as well. Only IDFC can issue infrastructure debt bonds or funds. Okay, so this was your IDFC. Going to the next one, 7th one. We have microfinance institution. Even this is an NBFC. We are going to learn detail of microfinance. Okay, so we'll be learning what is microfinance in that particular video only. So right now you can keep it aside. So we'll go to the next one, that is the 8th one. We have NBFC factors. You might have heard about the factoring business. This is that kind of NBFC which deals in factoring business. Now what is the factoring business? Suppose there is a consultancy firm. Okay, huge consultancy firm. They have huge various number of clients. So they provide services to the clients. Okay, what do they provide? They provide services to the clients and clients pay them money. But it's not that easy. Realizing your money, it's not easy always. So consultancy firm, what they do? They hire NBFC factors. Okay, whom are they hiring? NBFC factors. Now why they are hired? They are hired to realize the payment from the clients. Okay, so whatever bills are raised by consultancy firm, all the bills shall be transferred to the NBFC factors. NBFC factors shall realize money from the clients on behalf of the consultancy firm. right? Suppose consultancy firm has to receive 1 lakh rupees from Mr. A. The consultancy firm will not go behind that Mr. A. Rather, NBFC factor, they will go behind Mr. A and realize the money. So what will NBFC factor get in return? They will get commission on that. So commission is the income of your NBFC factor. It is called as a factoring business. It's a huge business when it's a financial activity. Clear with this? Understood? Great. Now there are certain requirements of this. Requirements. They require 50-50 test. So at least 50% of a set should be in factoring, and out of the total gross income, at least 50% of income should come from the financial assets of the factors. Apart from that, they require a set size of minimum of 100 crores. This is your NBFC factors. Now the next one, 9th one, we have a mortgage guarantee company. Mortgage guarantee company, when this is kind of an NBFC. So let's write it as MGC, Mortgage Guarantee Company. What this company does, this company guarantees the mortgage. We know that whenever banks give loan to the clients, okay, high chances are there the clients will default. High chances. Okay. So whatever mortgage is kept by the client mortgage is any of the property. If I take loan of 1 crore rupees from HDFC Bank, I will have to mortgage some property with them. Answer is yes. So once the transaction is done, okay, bank shall give this mortgage to the MGC. So whenever there is a default, bank shall not realize the asset and pay off to the client. Instead, MGC shall guarantee the mortgage on behalf of client. So if client defaults, MGC will be liable to do all the things which bank is required to do. Understood? So that bank has to concentrate on its core activity and not be behind the clients for the payments. Okay. So this MGC, the scheme is like this. Example, if any client take a housing loan, what the client is taking, housing loan, it shall be backed by mortgage guarantee. So what is the name of housing loan? Backed by a mortgage guarantee. So this mortgage guarantee NBFC shall give a guarantee on behalf of the clients. Okay. For that, suppose normal interest without your mortgage guarantee, normal interest is 10%. Then when you have a MGC, mortgage guarantee, you will have additional 2% or 1% interest. So now client has to pay 12% of interest, out of which 10% will go to the bank and 2% shall go to the NBFC, that is mortgage guarantee NBFC. That is their income. Clear? Understood? Okay. So they will help the banks to focus on their activity, also help the clients to take the loan easy way, and bank 100% guarantees the loan wherever there is a mortgage guarantee given by an NBFC. Clear with this? Understood? Yes, even client has to confirm. If I am taking loan of 1 crore, I have to pay 12%. So I have to confirm that yes, I am okay to take the mortgage guarantee. But if I am in need of loan, obviously I will be taking that, right? After that, the next one, 10th one, is a non-operating financial holding company. Non-operating financial holding company. This is an NBFC. Okay. How do we write in short? NOFHC. NOFHC. Non-operating financial holding company. Listen to this very carefully. Very interesting concept it is. Okay. Now suppose there is a holding company. Okay. Now there is a holding company which is Bajaj Finance. Now there is a company called as a Bajaj Finance. Forget about the holding company. It's a company called as a Bajaj Finance. I will drop this out so it will be easy for you. So there is a company called as a Bajaj Finance. Now the promoters of this Bajaj Finance, they want to do various activities. They want to open a bank. They want to open a company which is doing an insurance business. They want to do the NBFC business. Obviously they are doing it. They also want to do the chit fund business. They also want to do the underwriting business. One NBFC can do one type of activity, right? So promoters don't want that they should hold stake in all the company. Rather, they want somebody which will hold all this company. So there is an option available in NBFC. So there is a company called as a Bajaj Finance. Now Bajaj Finance, listen to this carefully. It incorporates an wholly owned subsidiary. What is a wholly owned subsidiary? I have explained you this in chapter number 4, where Bajaj Finance holds 99.99% shares. 0.01 is given to some promoter who will be holding in behalf of Bajaj Finance. Clear with this? So, wholly owned subsidiary of Bajaj Finance, say for example, ABC Limited. So this is a wholly owned subsidiary. Hence your Bajaj Finance became the holding of this. Clear? Yes. Now, this company is an NBFC and non-operating finance holding company. Now what is this? This company shall be holding a bank. Suppose they incorporated a bank called as a small finance bank. The name of the bank is small finance. It's a bank. Also they incorporated an insurance company. Also they incorporated a company which is doing underwriting business. Also they incorporated a company which is doing chit fund business. Okay, so this alone, this non-operative financial holding company, which is your A Limited, is holding all these NBFCs, all these companies. So what is the main activity or main business of this ABC Limited? Nothing. Just holding the financial companies. What is the main activity? Just holding the financial company. So whoever or whatever companies are doing financial business, it can hold all those. So this is what they are doing. Can they hold a manufacturing company? No, it is only financial company. The name itself says it will be non-operating. So ABC is non-operating. It does not have any business and only holding the financial companies. So by this arrangement, these promoters, okay, these promoters of Bajaj Finance are holding the small bank also, insurance also, underwriting also, chit fund also. Amazing, right? This is an arrangement possible and called as non-operating financial companies. Okay. Yes. After that, we have a last one. This was the 10th one, right? 11th one now. The last one. Very easy concept. NBFC non-deposit taking and systematically important. There is an NBFC which is not accepting deposits from public, but it is systematically important. So for this, what is the requirement? They cannot accept deposits from public, the first requirement. And the second requirement is the minimum asset size is 500 crores. Okay, clear with this? Understood? So these are the 11 types of subsidiaries, that is non-banking financial companies. One we have not discussed because that we are going to discuss in this chapter itself. In detail we'll be discussing there. Okay, so I hope you have understood all kinds of NBFCs. You have taken down the notes also. Anytime you feel difficulty, you can rewatch the video. So let's start with our next topic, that is incorporation of NBFC. We have understood now what is a NBFC, what are the types of NBFC. Now we are going to the incorporation, how to incorporate an NBFC. So if any entrepreneurs come to you and says I want to incorporate an NBFC, would be in position to explain them the process. So the very first thing, as I told you, NBFC is a company. So when it is a company, we need to incorporate the company as per Companies Act 2013. So we have learned this in chapter number 2, right? So we have to fill up Spice Plus form and take all the formalities, reservation of name, INC 9, memorandum, articles, director's consent, everything we have to do same. Few different things are there which we need to discuss. Whenever we are incorporating, in the memorandum of association, we have to write the object clause, and in the object clause we have to mention that company is going to do an NBFC activity. What we need to mention? Company is going to do an NBFC activity, and you have to specify which kind of financial activity it is going to do. Okay, so this object clause, this point is very important. If you don't mention that you are going to be an NBFC company, then the incorporation is not valid incorporation. Hence you have to make sure that we mention in the object clause we are going to do an investment activity or any other financial activity of an NBFC. So then once ROC is satisfied, that is registrar of company satisfied, it shall issue a certificate of incorporation. Yes, it shall issue us a certificate of incorporation. So once it issues certificate of incorporation, can we start the NBFC activity directly? No, because we have to take a license from RBI. So after certificate of incorporation is issued, the second step we need to go for obtain license from RBI. Now, if you are a housing finance company, would you obtain a license from RBI? The answer is no, because you need to take license from NHB. But we are not those category of NBFC. We are other NBFC category like investment, core investment, infrastructure, microfinance. Then you have to take license from the RBI. So before taking license, before application of license, we have to fulfill certain conditions. Okay, so what are the conditions which we need to fulfill? The very first condition is our authorized share capital. How much should be our minimum authorized share capital? I hope you have answered my question. At least 2 crore, because our net own fund has to be minimum of 2 crore. So our authorized share capital cannot be below 2 crore rupees. Okay. After that, at least one director, that is one proposed director of an NBFC He should be from an NBFC background. He should be from an NBFC background, or he should have experience in dealing with the bank. So he should be senior official of the bank. Senior official of the bank. So one person should be having knowledge of NBFC activities basically. Also, his record of CIBIL is a credit rating agency, right? He should not be a defaulting character. So his CIBIL record should be clear. He should not be a defaulter, because a defaulter cannot be director of an NBFC. And he should have a decent knowledge about NBFC. Clear? This was a requirement. First, authorized share capital, and second, about one of the director. Now next one, the third one. The first step was incorporation we did. Second step, you have to obtain license. Before that, we fulfill certain condition. And then now third step, we have to apply for license from RBI. So now we are applying for license from RBI. We have to go through two procedures. One is the online mode. Another one is the offline mode. Okay. Online mode. Another one is a offline. So first step is an online mode. This is A and this is B. Basically, you have to fill up the form online, take the printout, attach all the physical documents and go to the RBI office and submit them. This is how you go through. But the first step, you have to start. Visit a website called as www.cosmos.rbi.org.in. This website we have to visit. In this website, we have to click on company registration. We have various registration under this RBI website. So we have to click on the company registration. Now your form will be opened. Okay, so when your company registration form is opened, form shall open. You have to fill in the details. What do you have to do? You have to fill in the details. Very important detail will be about regional office of RBI. Wherever your registered office of your company is situated, there which RBI is regulating. So which regional office of RBI is applicable to you. So you have to fill in the details of regional office of your RBI. So it will depend upon where your registered office of the company is situated. So once this is done, you fill in the details, then you submit the form. So once you submit the form, you will get an acknowledgement. That acknowledgement is in CARN shall be generated. What shall be generated? CARN. What is CARN? CARN is company application registration number. Company application registration number. Okay, so we fill in the form, submitted online, and CARN was generated. This CARN just like your acknowledgement number. Anytime you want to know what is the status of your application of license, then you can just put in the CARN and you can know the status. Okay, so once CARN is generated, half of your task is over. Okay. So now the fourth step, we have to take print of the form, that is application form plus CARN. we have to take print of this. After that, you have to attach physical documents. What you have to attach? Documents physically. You don't have to apply it online now. You have to attach the documents physically. After attaching the documents physically, you have to submit to our regional office of RBI. You have to go physically and submit to regional office of RBI. Okay, my task is over. Just we have to know that what are the physical documents we require. So now we are going to learn what are documents we need to attach in the application. Documents require. First thing we require is certificate of incorporation, which we received from our ROC, plus we have seen the compliance under INC 20A, that is commencement of business compliance. We need to do that as well. Okay, after that we require just a extract of object clause. We don't have to give entire memorandum articles, but we have to just attach the extract of the object clause where the activities of NBFCs are there. That's it, nothing else. After that, we have to attach various board resolutions. Okay, now which board resolution which we need to attach? The first board resolution will be that the company is not carrying on any NBFC activity. Okay, the company is not carrying on any of the NBFC activity and shall not start without the approval. Shall not start without the approval. This you need to give under a board resolutions. Okay, students, remember the process is very easy. Only the challenge is to remember the documents. So if you know the documents very clearly, you are done with this chapter. Okay, so till now the first resolution was company is not carrying on any of the NBFC activity and it shall not carry on without approval of RBI. Secondly, we have to attach the financial statement of the unincorporated bodies where your board of directors are interested. Okay, see, unincorporated bodies means what? The partnership firm, sole proprietor. So where such directors are interested, director may be partner of the same, right? So wherein your board of directors are interested, those unincorporated bodies should give declaration that these unincorporated bodies are not accepting the deposits. Okay, so wherein your board of directors are interested in unincorporated bodies. Board of directors are interested in unincorporated bodies. They should certify that they have not accepted deposits from public and in future also they don't intend to accept. Okay, incorporated bodies, wherever your directors are interested, they cannot accept the deposits. This was the second board resolution. Now the third board resolution says that your NBFC, proposed NBFC, it has adopted something called as Fair Practice Code. Fair Practice Code. Okay, because Fair Practice Code has to be adopted by all the NBFCs. This code is given by your RBI. So company has accepted the fair practice code as per RBI guidelines. So this is the third board resolution which is required. The fourth one says that our NBFC, if it is an existing company, so company has not accepted any public deposits. Company has not accepted any public deposits and shall not accept without RBI approval. Without RBI approval. Got it? Understood? The last resolution now. Your company does not have customer interface. What company does not have? Company does not have customer interface and shall not create without RBI approval. Okay, what is customer interface? Before taking license from RBI, you have started publishing everywhere. We are going to the NBFC, we shall give you this many products. So you are already creating your customer interface. So that is not allowed to be done. Once you receive license, then only you can start building your customer interface. So I hope you have understood the 5 board resolution which we need to attach with our application. Okay, so these are the 5 board resolution. Now after this, we need to attach a fixed deposit receipt also. What we need to attach? Fixed deposit receipt or a bank certificate. See guys, understand. What is this? We have authorized share capital of 2 crores. That 2 crores, are you going to keep in at your home? Is that in cash? No, it will be definitely in a bank account. So, will not keep cash lying, right? We need to earn on the cash, that is on the money. So, you either create a FD or if you have 2 crore in your bank account. So, that certificate is required to certify that you have a authorized share capital of 2 crore. So, this is a certificate given by your bank. After that, if you are an existing company and this existing company wants an NBFC license, so in that case you have to submit your financial statements along with the auditor's report, along with the director's report. Okay, this you have to submit for 3 consecutive years. Previous 3 years financial statements along with the directors and auditors report has to be attached for previous 3 years. After that, we require banker's report also. Why banker's report is required? See, your company, that is proposed company, that is your NBFC, plus there might be your holding company also. There might be your subsidiary companies also, your associate companies also. All this will be having bank accounts. Okay, so report is required from all bank accounts. Report is required from all the banks that how are these companies doing? Are they defaulting? Is their behavior good? Interaction good? This report is required from all the banks. Suppose holding company has 5 bank accounts. So from 5 banks, it has to give a report. All this will be attached to the application of the NBFC. Clear? Understood? So once we file all these documents, this is the 4th one we filed. Now the 5th one. If RBI is satisfied, okay, it shall grant us license. What it shall grant? It shall grant us license, and after this you can start with your NBFC business. I hope it was very clear. As I told you, the challenging part is just to remember the documents. Apart from that, everything is fine. Okay, got it? Great. Now, let's go and see what are the benefits of incorporating an NBFC. We have seen how to incorporate NBFC now. Now, what is the benefit of incorporating an NBFC? First one, they provide for the competitive interest. Competitive interest means, as I told you, your banks and NBFCs are rivals. Both want to make their business big. That's good, no? Because more they will have good products for the customer, more different kinds of options available in interest rate, our economy will grow as a whole, right? So the rate of interest is very competitive, and it depends on the types of loan. And to NBFCs, as I told you, Banking Regulation Act is not applicable, so they have little flexibility in the interest rate. So it's not rigid like a bank that when it's a housing bank you have to get only at 12%. No, this can be flexible. Okay, so NBFCs can bring down the interest rate equal to bank rate or sometimes even lower than the bank rate. So what happens? The EMI is also less. So number of loan, amount of loan will be more, right? Yes, and now interest rate is based on what? It is based on income, credit score, repayment, interest. So rates are very competitive. Also, the processing is very quick, not like bank. Even nowadays, bank has also improved a lot, but you can get instant loan. Processing is very quick. Why? Because banks has to follow the rigid regulations of Banking Regulations Act. NBFCs don't have to follow. They have flexibility. So NBFCs are lenient. It makes the loan approval process easier, smoother, and very quicker also. Okay, so sometimes when you are immediate need of money, you will get it from the NBFC. So people now started going to NBFC instead of going to the banks. Okay, so NBFCs has taken the opportunity to meet quick demands and process loan at competitive rates. Then NBFCs have to follow less rules and regulation because they are not stringent as the banks. Because of this, it is less complicated loan process. Time is also saved. Understood? So loan amount is improved at less collateral value. So basically in banks, what happened, whatever is the collateral value, that much amount of loan is given to you. NBFCs, what they do, they don't give you that much amount of loan, but they will give you little less than collateral value. Sometimes they can give you without collateral asset also. So it's an unsecured loan, even that can be given. And NBFCs also don't want to maintain this reserve ratio, so they can open n number of branches at their will, no problem at all. Then loans are available to the individuals with the poor credit rating. See, generally in banks, your credit score has to be around 600 to 650, then only you will get loan from a bank. Otherwise, it is difficult. But it is not in NBFC. What NBFCs can do? Charge higher interest where the poor credit rating is low. Understood? So where credit rating is poor, they charge high rate of interest, but individuals get the lower. Understood? So individuals with the poor credit rating, they don't get loan from the banks because they are high risk individuals. So their credit score has to be around 600 to 650. But NBFC, most of the time they charge higher rate of interest. Due to this, the people with poor credit rating, They go to the NBFCs instead of the banks. After that, they offer various kinds of loan, business loan, personal loan, durable loan, every kind of loan. You want to buy Apple phone, go to the NBFC, they will give you loan. Okay, so they will offer various kinds of loan. It depends on the capacity of borrower, how much it can borrow. You will get all kinds of loan. That is how your NBFCs are expanding. So these are the 5 advantages of NBFC. I hope you have understood how to incorporate NBFC and what are the benefits of NBFC. So let's start with the housing finance company. Okay, now we are going to learn various kinds of NBFC which does not require license from RBI, but they require license from other regulatories, that is NHB. So a housing finance company will not require license to start its business from RBI, but it will be taking license from an National Housing Bank, NHB. So who is a regulating authority for housing finance company? It's an NHB and not RBI. But your NHB is an NBFC. Your NHB is an NBFC. Okay. So what is this HFC? Housing Finance Company. Now, Mr. A wants to buy a property. For that, he needs to take a loan. So he goes to a NBFC which provides them with the housing loan. Okay, there is one kind of NBFC which provides them with a housing loan. So such kind of NBFC which finances housing is called as an HFC, that is Housing Finance Company. So what is the main activity of your HFC? The main activity of HFC is financing house. So anybody who wants to take or purchase house, loan can be taken from a housing finance NBFC. Very clear with this? Understood? Okay. Now what is an HFC? HFC is nothing but it is a company which is incorporated under Companies Act 2013. I am writing shortcuts, but in paper shortcuts are not allowed, guys. Please remember. So it will be incorporated under Companies Act 2013, but it shall not obtain license from RBI, but it shall obtain license from NHB, National Housing Bank. And which law is applicable? RBI Act 1934 will not be applicable to them, but there is a law called as National Housing Bank Act 1987. This will be applicable to the HFC. So regulator is NHB, regulating law is National Housing Bank Act 1987. Clear? What is the main activity of HFC? Will finance your house. Simple. Okay. Now, as I gave you example, Mr. A want to buy a property, want to buy a house. So, Mr. A approached HFC for the loan. So, when Mr. A approached HFC for the loan, one point to be remembered about HFC, it only gives secured loan. Which kind of loan? HFC gives only and only secured loan. So loan will always be backed by an underlying security. So when HFC is given 10 crore rupees to Mr. A has to keep something in mortgage with him. It can be any property, movable, immovable, does not matter. So HFC gives him loan of 10 crore, but he will require one asset to be kept as a mortgage. So Mr. A gives his factory, which is worth rupees 10 crore. So how much loan can be given? First of all, it is only secured loan. And how much loan can be given? Only up to amount of the security or less than that, but it cannot exceed the amount of security which is mortgage. So if I have a property which is worth 10 crore, how much loan I can get from HFC? Only and only 10 crore rupees or less than that, but it cannot exceed 10 crore rupees. Simple? Understood? Great. So Mr. A took a secured loan from an HFC by mortgaging its factory worth rupees 10 crore. So now when application is given, okay, when application of loan is given, what shall HFC do in this case? HFC, it will first evaluate the asset. Which asset? Which we are going to keep as a mortgage. So what they will do? They will evaluate the asset and they will take out what is the value. Okay, so your loan amount shall be less than or equal to value of the asset which you have mortgaged. In any case, it cannot be more than that. Clear? Understood? So evaluation is done. So now loan is granted. Do you think HFC will sleep now? No. What will HFC do? At regular intervals. What shall HFC do? HFC shall at regular intervals. Okay. Say for example, this loan, it is for 10 years. It will be repaid after 10 years. So at regular intervals, HFC shall do evaluation of property. Because what happens? Today, when loan was granted, the market value of property was 10 crore. That is okay. But after that, in those 10 years, many fluctuations may come. So, when this evaluation is done in the regular intervals, whatever asset is kept, our asset is a factory, right? Okay. So, when they have done evaluation, if value has increased means the price of the factory was earlier 10 crore, now it has increased to 12 crores. What will be the action of your HFC now? What will your HFC do? Nothing. They'll be happy. Our loan is covered. Because by chance Mr. A defaults, they will have to sell the factory. And when they sell the factory, if there is no market value to it, then what will happen? Understood. So evaluation is done. No action. Okay. HFC will be satisfied. What about the other thing? If value has decreased, if value of the property has decreased, suppose if your value was 10 crores and now the market value is 9 crores only, reduced by 1 crore. So what will be action taken by the HFC? HFC shall ask the loan taker, that is a mortgager, to please give another security of that difference. Okay, so what it shall do? It shall ask for extra security. Whatever is a deficiency, they have to fill up that deficiency. I hope you are understanding what HFC does. So what we have seen till now, HFC only gives secured loan. At regular times, it will be evaluating the assets. If they find the value is increasing, that's great. But if value has decreased, they shall ask for the additional security just to cover the risk, nothing else. Because if your borrower defaults, then what is the way out available to the HFC? Only that property. That's why they shall always cover up the risk. Now going ahead, we are going to incorporation of HFC. How to incorporate an HFC? We are going to learn that now. Now, as I have told you, it's a company, so it will be incorporated under Companies Act first. So let's write the first point. It shall be incorporated under Companies Act 2013. Okay. When this incorporation is done, its object should mention that it is a housing finance company. If this object is not mentioned, the incorporation is not correct. So object of the company should mention that it's an housing finance company. Now the second point, once incorporation is done, once ROC issues a certificate of incorporation, now we have to obtain a license. So are we going to obtain license from RBI? No, we are going to obtain license from NHB now. So obtain license from NHB. I'm writing short form over here. You don't have to write the short form. So before obtaining license, there are certain requirements. Now what are the requirements? The first one says that the main object of your HFC, it should be financing the house property. What is the main object? Financing the house property. The second requirement is minimum net own funds requirement. So the minimum net own funds should be 10 crores or more. For normal NBFCs, which is not an HFC, requirement is 2 crore. But when you want to become an HFC, the minimum requirement of net own fund is 10 crore rupees. Okay, so if these two requirements are satisfied, we can apply to the NHB. So the third one, we are going to apply to the NHB. Application to the National Housing Bank. We have to visit the website www.nhb.org.in. Okay. We have to download the form. Also, this is done online also now. Okay. You have to take print of this form and then you have to attach the documents. Once you take print, you have to fill in the details in that. After that, you have to submit duplicate copy of the form and you have to attach necessary documents. What are the documents? That is not relevant for you over here, but duplicate copy along with that necessary documents. These you need to submit at the head office of NHB. Where you need to submit? Submit at head office of NHB, which is at New Delhi. So you need to submit the documents at the New Delhi. Along with these documents, how to pay fees, you either pay online or you have to attach a demand draft. What do you have to attach? A demand draft which will be payable at New Delhi. For payment of the fees is rupees 10,000. So for registration of HFC, you need to pay 10,000 rupees. Clear? So over here we are not going to regional office of RBI, but we are going to the office of NHB, that is at the head office. This is done online also, but still offline applications are accepted. Clear with this? Everybody understood? Now we are going to see the requirements. So once we have given application, NHB will look into various conditions. Okay, so these are the conditions which NHB will look into. In NBFC registration, documents were important. Over here you have to remember the conditions. So NHB will look into whether these conditions are fulfilled or not, then only it will grant you registration. So over here documents are not relevant for you. So what is the first condition? That your HFC, your company is capable or in position to pay off all your depositors, present as well as future. So that means you are a solvent company. Any insolvent company, HFC cannot be given a license. Okay. After that, affairs of your HFC, okay, the business, the affairs of HFC, they are in interest of the depositors and interest of the public at large. They are not detrimental to the interest of the present or future depositors. Then your management character, your board of director character is not against the interest of the deposit holders or the public interest. It is an interest of public as well as the depositors. You are having an adequate capital structure. Also, you are having a very good plan for the earning prospects in the coming years. Then they will also check if certificate of registration is granted to any HFC, it is going to serve a public interest, then only it will be granted. NHB will also check that if certificate of registration is granted, it will not be prejudicial to operation of existing financial sectors. They will see to it. After that, very important thing, NHB will check two things. It is not an interest prejudicial to interest of public or the depositors. If it is in both interest, it may grant you a license. What it may grant you? A license. So once license is granted, you can start your business of your HFC. I hope you have understood the concept of your HFC. So this was your incorporation. Now the last part of HFC talks about benefits. Why will any entrepreneur incorporate an HFC? See, HFC basically gives loan. So it requires more and more people to take loan. Now, what is that drive which will create one person to purchase property and take a loan on that property? So what are the benefits? The first benefit is our Modi government has given various incentives in Pradhan Mantri Awas Yojana. Awas means residence. It is giving more benefits to the people. People will be buying more and more properties in the coming year and hence will take loan for that. So the benefit is allocated as 23,000 crores and they are also in limelight to create an infrastructure because residence is not enough. No, we require good infrastructure facilities also. So they have budgeted around 39,6135 crores to be used for the infrastructure. So this is also a drive. Also they have made changes in the capital gains. So if you are holding a immovable property for 2 years, now the capital gains will be applicable to you. Also, you have various benefits on that. Also, the indexation base year is shifted from 81 to 2001. So what is this indexation? I will tell you that. Suppose you have purchased property in 1950 and you are selling that property in 2022. Are you going to take price in 1950? In 1950 you purchased this property for 5 lakh and today price of that property goes to 5 crore. So capital gains is applicable, that is long term capital gains will be applicable to you on the profit, right? See how much capital gains you have to pay, 5 crore minus 5 lakh, on that amount you are going to pay. So there is an indexation year. So when you want to sell property today, earlier year was you have to consider price of 1981 if you are selling it today. So price in 1981 was around, say for example 20 lakhs, but today property has gone to 5 crore. So that the profit goes less. But now this 81 has been again extended and they are going to 2001. So in 2001 the value of that property was around, say for example 90 lakhs and today you are selling it for 5 crore. Don't you think there will be so much of difference? Less profit, less taxes. So because of that, people will like to sell their property, old property, and exchange, buy a new property. For buying new property, they have to take loan from the HFC. Clear? This is called as an indexation. So it allows more realistic calculation of cost of acquisition while claiming the indexation benefits. Also, now there is a world of digital documents, so your physical documents are not there, so the cost of finance comes down. So this is also a impetus for individuals who really want to buy the flats. Also, there are various benefits given, and now tier 2, tier 3 cities are coming up. So now the cities where actually there is no development, the development is happening, people are migrating because everybody wants flat near their office, and offices are migrating to zero development area, over their development is happening. So this all will lead to buying of more flats and also taking the loan. So now there is a huge scope for the HFC. Okay, I hope you have understood what is HFC, benefits of HFC and how to incorporate an HFC. Okay, this is all for HFC. Now we'll begin with our next topic, that is Asset Reconstruction Company, ARC. This is very interesting. See, now let's understand this. Various banks we have like HDFC, Axis Bank, ICICI Bank. What all these banks do? They give lending, borrowing. Borrowing is okay, but they also provide with the loans. So when loans are given, okay, some loans are repaid on time. So for some loans we receive repayment on time, but for the other loans they are defaulted. Okay, and now this default is a big problem. Default is a big problem for the banks. Why? It is not just one loan which is defaulted, but huge number of loans are defaulted. So this will impact on the balance sheet of your bank. So when this impact on the balance sheet of a bank, now whenever you are going to borrow or lend to the bank, you are obviously going to check the balance sheet of the bank, and when it appears to you that so much of default is there, asset is there, but against the asset so many defaults are there, will you like that bank? The answer is no. So many banks are facing with this problem of default. People take the loan, they use a credit card, they take all the borrowings from bank, but they don't repay it on time. So this is a big problem. And if your bank is not correct, the bank structure, the bank balance sheet is not correct, our 80% of your economy is dependent on the banks. If the banks are good, economy is good. If our bank's balance sheet are not good, what will happen? I hope you understand. Okay, so this is a big problem. This spoils bank's balance sheet. Ultimately, it is spoiling our economy. Now, this was first time seen by Narsimha. Sounds like some Simba like, but there's a Narsimha committee. Our government makes many committees. Okay, so for every committee, different tasks are given. So Narsimha committee first time saw this and it said to the government, this is a big problem because banks are dealing with various bad debts. See, in a bank, there are two kinds of asset. Narsimha committee said that some are performing assets and some are non-performing asset. Performing assets and non-performing. Performing assets means what? The payment is done on time, no problem. Those are performing assets. You're performing loans, liabilities. But what about the non-performing? These are our big problem, bad debts. So Narsimha committee suggested that for the non-performing asset, we should have a recovery debt fund. Also now they have come with the concept of bad bank, right? If you have heard about the bad bank. Okay. But this was not enough. We require a different mechanism. So then our parliament came up with an act called as SARFAESI Act. Which act is there? SARFAESI. These are just initials. Now we'll write the full form of this act, called as Securitization and Reconstruction. Securitization and reconstruction of financial asset and enforcement of security interest. Act 2002. This is the name of an act. What is the name of the act? Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. Under this act, they created someone called as ARC, that is Asset Reconstruction Company. Asset Reconstruction Company is an NBFC. Now, what is the main duty of this Asset Reconstruction Company? Asset Reconstruction Company will separate non-performing assets from performing assets. So they will separate, I'll write in NPA, non-performing asset, non-performing assets of bank from performing. So what it will do? It will separate the NPAs from the performing asset. They will buy the NPAs. What they will do? Buy the NPAs from the bank. I'll show you the example for this, don't worry. they will do enforcement of that also. Enforcement of security. What they will do by buying the NPAs? Are they going to do charity? Are they going to pay the amount to the bank like that only? No, even ARC is doing a business. So ARC will buy the bad loans, defaulting loans from the bank, and they have a specialized machinery, a mechanism to realize them. So they will do everything for realizing the debts. Understood? So let's understand with the help of an example. So enforcement of security, how they will do? By reconstruction of asset or securitization of asset. I know this all things are new for you, but you will learn it. They can also do by changing the management of company. Okay, now let's take an example. There is an ARC and there is a bank. Now in this bank, there are certain performing assets and there are certain non-performing assets. Suppose non-performing assets, they have 1 crore of that. Okay, how much is a non-performing asset? 1 crore is a non-performing asset for bank. So now there is a meeting between ARC and a bank. So ARC proposed to buy the NPA for rupees 75 lakhs. So ARC shall buy NPAs at discount because obviously they are NPAs, that's why. If bank agrees, if there is a deal, okay, if there is a deal, what will happen? All the NPAs, whatever are the bad dates, NPA shall be transferred to ARC. Okay, ARC shall pay 75 lakhs to bank. Just imagine, this is a balance sheet of your bank where 1 crore default is there. Instead of this 1 crore now, instead of this 1 crore, they already got 75 lakhs for this. So how much is a bad date? Only 25 lakhs. Don't you think it's a good deal for a bank? Yes. So bank will close this. Okay, close this by just writing 25 lakhs as a bad date. Loss. So for bank, the burden is gone now. They have to just pay 75 lakhs. So they have to just pay 25 lakhs for that as a loss. That's it, nothing else. So now don't you think bank can concentrate on its core activities instead of going behind the parties, please pay our money. Okay, now this NPA was transferred to ARC. Now ARC has a very strong mechanism. They can convert NPAs into performing asset. Okay, they can convert NPA into performing asset. How? They have all the expertise. Have you heard of Goldman Sachs? It's a ARC. Okay, they have all the expert people who will do all the things. Okay, they will sell the house or attach the property of the debtors. They will force them to pay. Obviously, they'll take all the legal ways to realize the debts. So they will try to convert NPA into performing asset, but it is not always possible. Okay, so say for example, they bought this NPA at 75 lakhs. Okay, they were able to take out or realize 85 lakhs out of it. The entire 1 crore was not possible, but they were able to take out 85 lakhs out of it. Don't you think 10 lakh is a profit for them? I hope you understood this entire scheme of the ARC. So what does your ARC do? It purchases non-performing asset from the bank at discount, and thereby bank can clean their balance sheet by booking a minor losses. ARC will do all the things: enforcement of security, securitization, reconstruction of asset of that. Will try to convert NPA into performing asset, try to realize as much as possible. If they receive more than the buy value, they'll make profit. In business, losses also happen. That is okay. Clear with this? Understood what is an ARC? Great. Now we'll go to incorporation of ARC. Incorporation of ARC. ARC is an NBFC. I have told you it has to be incorporated under Companies Act 2013. Okay, it can be private company also, or it can be public limited also, no problem. It can be private company also, it can be public company also. Okay. Second requirement says that it has to obtain license or it has to obtain registration. Now over here they have to obtain registration from the RBI only, that is true, but not under RBI Act. RBI Act is not applicable to ARC, but SurfAC Act is applicable. So they have to obtain registration under SurfAC Act 2002. In exam you can write short note of SurfAC, that is okay because the name is too big. So SurfAC Act 2002, if you write, that is okay, you will get marks. Okay. Now for obtaining registration, we have to make application in form, and where you have to make the application, you have to make application to Department of NBFC, Central Office of RBI, Cuff Parade. Okay, we have to make application over here. After that, once application is made, if RBI is satisfied, it may grant you a license for ARC. So RBI may approve the registration. So once registration is approved, what do you have to do? You have to start your business of ARC. So if you don't start your business within 6 months, you have to apply for the extension, otherwise your registration shall be invalid. So once approval is given, once approval is granted, ARC shall start its business. ARC shall start its business within 6 months. Within how many months? 6 months, or they have to apply for extension. Okay, who will give extension? Obviously they have to apply for extension with the RBI only. RBI may grant extension. Okay, RBI may grant extension. If found correct, they may grant extension, but only further period of 12 months, not more than that. For further period of 12 months. Okay, so once registration is granted to you, you have to start your business within 6 months. If not possible, take extension from RBI. If you don't take extension, RBI may cancel your registration. Clear with this? Understood? Okay. Now, after that, there is minimum net owned fund requirement. See, earlier net owned fund requirement for ARC was very less. Now there is an amendment. So minimum net owned fund requirement for ARC is at least 100 crores. Why? Because it is going to realize NPAs of the bank. So definitely your net owned fund should be more. So 100 crores or more. Now, as I told you, this is an amendment. So this amendment has come in recently. So all the existing ARC, they have to comply with this net owned funds by 31st March 2019. There, if they don't comply, their registration may be cancelled. Clear? After that, the next requirement is filing of quarterly reports. So every ARC has to file quarterly reports. Okay, quarterly reports means every quarter, every 3 months they have to file these two forms. Which one? The first one in SCRC1 and second one SCRC2. Okay, in these two forms they have to file online with RBI. Okay, these forms will be filed online with the RBI, and what will be given in this form? They will write what are the transactions they did in this quarter, they purchased whose NPA, how much was realized, if profit, what is the profit, if loss, what is the loss, how did they do the enforcement. Entire detail has to be given in SCRC1 and SCRC2. Now, what is the time limit for filing this? Time limit for filing this, once your quarter is over, within 15 days of that. Okay, so within 15 days of completion of the quarter. Clear with this? Understood? Okay, so this was incorporation and this was your ARC. Few things I want to mark for you in our notes. You have to see these notes we are writing, these are for the last minute revision, but you have to read the language from our JKSC book. Yes, so few points we have to learn about ARC. ARC isolates the non-performing asset. They free the financial system so they can focus on their core activities, and they also facilitate the markets. Now we'll see what are the benefits of incorporating an ARC. Why we should incorporate ARC? Because this will help bankers to get rid of the defaulting borrowers. Okay, whatever the cumbersome activity of realization that is done by the ARC, for that ARC earns a profit, obviously. So banks can concentrate on their core business. After that, it also helps the depositor or investor to build confidence in the bank, right? And ARC can also maximize the recovery value, thereby reducing the cost. Because ARC has the expertise, banks may or may not have expertise. Also, how much banks will pay, they have to appoint agents or expert people for that, and they have to pay due salaries. The same thing can be done by the ARC, which is its main business. So better ARC do that, right? Then it also helps in building industry expertise in loan resolution and restructuring the management, because they will serve as a catalyst for bankruptcy issues. It plays very vital role in developing the capital markets. How? I am going to teach you something called as a securitization. The securitization will be learning in chapter number 10. Then you will understand how your bad debts can be taken to the capital markets. Equity, not equity basically, but debt can be raised through it, and this is how you grow your capital market. Okay. The registration of ARC we have seen, application has to be filed with the RBI. Yeah. So we have covered all the points over here. So let's start with our next type of an NBFC. Now we are going to learn about microfinance institution. I hope you remember we had kept this institution aside and I had told you we'll be learning in types of NBFC. So what is this microfinance institution? It is an NBFC. Okay, microfinance institution is an NBFC and it is not like your HFC or ARC which is governed by different act. Microfinance institution is an NBFC which is governed by your RBI Act 1934, same act. Hence your regulator is RBI. So microfinance institution shall require license from RBI. Okay, under which act? Under RBI Act 1934. So it is not into the exception cases which you are learning, that is for HFC, NHB is a regulator, mutual fund, SEBI is a regulator. So MFI is not that kind of an NBFC, but it is governed under RBI Act 1934 and it is regulated by RBI. It need to obtain license from the RBI itself. So what is the speciality of this MFI? MFI deals with the poor strata people. Okay, it deals with which people? Poor strata category of people. What is this poor strata? Poor strata category of people means who is having the household income very less. They are below poverty line. This poor strata people, they also have financial needs, right? Definitely. Financial needs are also there for poor strata people, and that financial needs sometimes are like even for earning their livelihood they need. Sometimes they don't have money to even buy food for them. Okay, so it is those strata of people whose income is very low. So whenever they need any of the financial help, banks and all are not good option for them. Why? Because this strata of people mostly are from rural or semi-urban areas. Okay, these people are from rural or semi-urban areas. So over there, number of banks are very less. So they don't have access to the bank. Even though they have access to the bank always asks for collateral. Do you think poor state of people will have collateral security? Answer is no. They shall not have collateral security. I hope it is clear. Okay, so MFIs deals with the poor strata people. The function of MFI will be same, borrowing and lending funds, but to whom? Poor strata people in urban, in rural or semi-urban areas who don't have access to the bank or who don't have any collateral security. Clear with this? Understood? Okay. So now when we talk about the MFIs, we will write it in shortcut. MFIs. MFIs in India are of two kinds. One is about your non-profit organization. Okay, so there are MFIs which are Section 8 companies, which are Section 8 company who really help this kind of a people in coming up. And other kind is an NBFC. Other kind of MFI is an NBFC. So in this chapter, which one we are going to learn? Definitely we are learning NBFC and we are not learning the Section 8 MFI. Okay, clear with this? Great. Now, what is an MFI? Let's understand one more time what is an MFI. MFI is an NBFC who require license from the RBI under RBI Act 1934. They deal in poor strata people who are living in urban or semi-urban areas. Very clear with this. Understood. Okay, now we'll go ahead. Now MFI should have minimum net owned funds. Okay, they should have minimum net owned funds of rupees 5 crore. What is the fund requirement for MFIs? 5 crore is a fund requirement, but there is exception to this rule. There is an exception. Now what is the exception? Now MFIs in northeastern region, MFIs in northeastern region, that is your Meghalaya, Sikkim and all, right? Northeastern region. For them, net owned fund requirement is only rupees 2 crore or more. So areas other than northeastern region, it is 5 crore. And for northeastern region MFIs, the only minimum net owned funds requirement is 2 crores. Clear with this? So this is a requirement of net owned funds of an MFI. So I hope you are understanding the concept of an MFI. We'll go to your notes also and underline important points in that. Okay. Now very important part of your MFI. Now there is a test of MFI. There is a requirement under that. It requires at least 85% of net assets. MFIs, 85% of net assets should be qualified assets. 85% of net assets should be qualified asset. Now what is the meaning of qualified asset? Specifically for MFIs we are going to learn over here. So out of 100 rupees asset, 85% of net asset means what? Excluding the cash and bank balances, right? So 85% of its net asset should be following. Now what is a qualified asset? Qualified asset means loan given as per following requirement. Loan given as per the following. So we will learn over here. So now we are going to learn the definition of a qualified asset. So what is a qualifying asset? They have to give loan. MFIs are required to give at least 85% of its net assets loan to those individuals, who are living in rural areas, and their total household income is not exceeding rupees 1,25,000. It is not exceeding rupees 1,25,000 per annum. Okay, or to those individuals who are living in the urban areas or semi-urban areas, individuals living in semi-urban areas, and their household income, it's not exceeding rupees 1,50,000. Okay, household income means what? If all of them are working, then everyone's household income together put cannot exceed 1,50,000 in semi-urban and 1,25,000 in case of rural areas. Clear with this? Understood this? This is the first criteria. So it's 85% of its asset should be loan given to such kind of individuals. Okay. After that, second criteria talks about the loan cycle. What is the system for the loan cycle? There will be first cycle. So first time anybody comes to MFI, they can give loan up to rupees 75,000. And the second cycle, the subsequent cycle, it cannot exceed rupees 1,25,000. Okay, so anybody's indebtedness cannot exceed 1,25,000. Clear with this? We will write that in the third point. So the total indebtedness. What is total indebtedness? Indebtedness means what? If I have already taken loan of 75,000, now I require extra loan. Can they give me again 75,000? No. They will only give me 50,000 because my total indebtedness cannot exceed 1,25,000. Okay. Total indebtedness of an individual cannot be exceeding rupees 1,25,000. Okay, but there is an exception to the rule. What is an exception to the rule? Exception says that the loan taken, okay, loan taken for medical or education, it shall not be included. Okay, it shall not be included. This was your third point. After that, what is a requirement of your collateral security? Do they require a collateral security? No. MFIs provide loan without a collateral security. They provide loan without a collateral security. So loans provided by MFIs are unsecured loans, because if they also ask for the collateral security, then what's the difference between MFIs and banks? Understood? Okay, coming to the tenure of the loan, where the loan amount, okay, where the loan amount is more than 30,000, loan amount is more than 30,000, the tenure should be minimum of 24 months. Why such a long tenure? Just think, you are talking about those people whose annual salary is not exceeding 1,25,000 or 1,50,000. Understood? So obviously, how can they repay their money so fast? That's why the tenure is given as 24 months. After that, whenever MFIs are giving loan, the maximum loan should be given for the income generation. So MFI should concentrate on giving more of the business loan and less of the personal loans. So MFI should concentrate that at least 50% of total loan is given for income generation. It is given for what? Income generation, that is for the business loans. Clear with this? Understood? So this is basically your MFIs. Okay, now we are going to see the registration of MFIs. For that, we'll go to the notes and to the markings. Now, what is an MFI? MFI basically offers financial services to low income population. So as I told you, they deal in the poor strata people. So they offer credits and other financial services to the poor strata population, because they also, being citizen of India, it is also their right to get loans, right? Now your NABARD has defined your microfinance as providing thrift, credit, other financial services to very poor people in rural, semi-urban and the urban areas, where two requirements are important. What are the two requirements? First, the transaction value, the loan amount will be very small, as we saw the cycle, right? First cycle 75,000, second cannot exceed 1,25,000. So loan cycle is very less and customers are very poor. So these are the two requirements as per the NABARD for the microfinance. Now going to the characteristics of MFIs. MFIs provide financial services to small and unstable kind of a people. Why? Because this unstable kind of people, they don't have good income, so they don't have savings, hence their need arise any point of time. They can be very sudden and needs are very small. Okay, needs are very, very small. So institution like banks and all, they demand the collateral security which these people do not have. So MFIs will be good option for them. So most of the urgent needs can be even for consumption of demand like education, illness. Sometimes they don't even have money to buy the food. Okay, also it can be investment and income generating activities, and these people, if they want to run a business, for that they want a loan, even MFIs can provide them loan. These are the main characteristics. Also they are called as a self-help group. Why self-help group? Because microfinance, you know what it does? Microfinance, it serves two kind of people, the members and the outsiders. So whoever are members of microfinance, it deals with them also. Also it deals with the outsider. So it has a huge exposure. So members or outsider who have extra money, they can lend to MFIs, and members or outsider who are in need of money, they can borrow from MFI. This is called as a self-help group. But even Nidhi company is a self-help group. But why it is not an MFI? Why it does not require license under RBI Act? Because Nidhi company only deals in the members. But MFIs deals with members as well as the outsiders. Clear with this? Understood? Okay. Now, what are the characteristics of MFIs? The characteristics of MFIs are the size of loan is very small. We have seen this. The repayment period is also very, very short. They mobilize the resources, as I told you, they get the resources internally with the members and externally with the public. No collateral is required for the loan. You need not mortgage your property for taking loan from the MFIs. The end use of loan is very flexible. If you have taken loan for education, you can also use for the medical, that is okay. Then mostly they give group loans. So when they give group loans, the cost of finance comes very, very less. It is cut down. Okay. Clear with this? Now we are going to incorporation of MFIs. Incorporation of MFI is same like incorporation of NBFC, which we have already seen. So when MFI is a company incorporated under Companies Act 2013. Okay, so it will be incorporated under Companies Act first. In its object clause, we have to mention that this will be doing activity of an MFI. Okay, after that it need to fulfill the net own fund requirement, that is the minimum authorized share capital. If not in northeastern areas, they have to keep of 5 crores, and if in northeastern areas, then 2 crore. Clear with this? After that they have to apply to RBI. Now how do we apply to the RBI? We have two rules. First we have to go to the RBI website, download the form, which form? Company registration form. Okay, then we have to fill up, very important, we have to fill up the correct regional office of RBI. After that submit the form. CARN, company application reference number, shall be generated. So once it is generated, we have to take print of that, go to the regional office of RBI and submit the documents, right? Same process, only few documents are additional which we are going to see. So over here we are going to see what are the list of documents required for registration with RBI. So certificate of incorporation, very important. Then extract of main object. Then we had seen the 4 resolutions, I hope you remember. The first one, our company is not carrying on any NBFC activity. It shall not carry on NBFC activity without approval of RBI. Further, company has not accepted any public deposit, and it shall not accept the public deposit without permission of RBI. After that, even UIBs are unincorporated bodies where your directors are interested. They have not accepted any deposit and shall not hold any public deposit in future. And the last resolution, that company has adopted fair practice code as per the RBI guidelines. These are the 4 resolutions. Along with that, we will require a FD receipt of bank certificate receipt. Why do we require that? for the verification or confirmation of your authorized share capital of company, whether company is having that much capital or not. After that, companies which are already existing, they will have to submit their past 3 years balance sheet, P&L, auditors report, directors report. Then they have to fulfill the education and qualification requirements of one director. So they have to give certificate how much qualification or experience your director is having. So experience certificate and the qualification certificate. Along with that, they require a banker's report. So your holding, subsidiary, associate, all the companies wherever they are having bank accounts, the bank shall give a report about their dealings with such companies, and that shall be submitted to the RBI. Now, additional requirement for the MFIs. So this is an NBFC MFI, so additional requirement. Now we will require few additional board resolution. First of all, your MFI, the proposed company, shall be a member of credit information companies. Okay, so it will be member of credit information company. This is one of the institution which keeps the credit information. So if I have taken loan of 5 lakh rupees, so that will be written in credit information that Vandita Doshi has taken loan of 5 lakh. Then when I return it, pay off properly on time, even that will be recorded. So whenever banks or MFIs want to give the loan, they can directly go to the credit information agency and check out about how is the credit rating. They need not go to the details of the bank accounts of a client. Okay, so this is work getting better, easier. After that, they are also a member of one self-regulatory organization. Over here, idea of RBI is that they should make their own rules and regulation and they should follow that. Hence, more stringent guidelines are not given to the MFIs, but it sees to it that they are at least self-regulatory. Then also one resolution that company is following or adhering to regulations of the pricing and the following non-coercive method of recovery. Non-coercive method means what? Suppose I have taken loan of MFI, I am from the semi-urban, I am not able to pay the loan. So can MFIs come to my place? Can they send the people who are criminals to my place and put gun on my forehead, take away all my ornaments? No, it cannot be done. That is a coercive method. Coercive is a physical threat. So over here, the method of recovery should be non-coercive. Okay. After that, MFI should fix their internal exposure limit. Okay, so that 2-3 MFIs are not dealing into same area. That is a thing. And over here, we are not dealing with section 25 or section 8 MFIs. Those are non-profit organization. We are dealing with only and only NBFC MFI. So if it is a section 8 MFI, it is not an NBFC. They will not get license of NBFC because NBFC cannot be a section 8 company. Please remember. Clear with this? Also, we have to achieve that 85% of qualifying asset, very important. Now, what is that? I have already explained you. This is all with your MFIs. Okay, on MFIs, you may get a case law or a direct question. So now let's start with the Nidhi company. Already we have learned what is a Nidhi company, right? So we'll be just revising few concepts of Nidhi company, and after that we'll be looking into the incorporation of Nidhi company. So now what is the Nidhi company? Nidhi company is defined under section 406 of Companies Act 2013. Earlier section number was 620A. What should be the main object of the Nidhi company? We have to focus on the main object. It will be thrift, providing credit and savings, creating the habit of savings among its members. Nidhi company shall only deal among its members. It cannot deal with the outsider. Just because of that, even though it's an NBFC, it is doing the financial business, financial services, it is exempted from taking license from the RBI. It is not governed under RBI Act 1934. Clear with this? Understood? Yes. So they are mutual benefit societies. Why do we call it as mutual benefit societies? Because members who have extra money, they keep deposit with the Nidhi company, and Nidhi company pays them interest. And those members who require money, they borrow from the Nidhi company. So this is called as a mutual help. Okay. So they deal strictly only with the members, and members are only individuals. So members of Nidhi company cannot be a body corporate, cannot be a partnership, cannot be any artificial entity, but it is only and only individuals. Okay. So principal source of fund is contribution from the members. They can give loan to members at cheaper rate. They can take loan from members at higher rate of interest, that is allowed. So Nidhi company is governed by Nidhi rules 2014, and it is always a public limited company, we know that. It cannot be a private limited company with minimum paid up share capital of 5 lakh rupees. Can they issue preference shares or debentures? The answer is no. They can only issue the equity shares. So Nidhi company do not require RBI approval. They just need to register with the Companies Act 2013. Now, what are the characteristics of a Nidhi company? They can transact business only with its members and not outsider. So how can a person become a member? They have to subscribe at least 10 shares worth rupees 10 each, or 100 rupees of share. Okay, so this is how we can become member, and then we can start dealing with the Nidhi company. Nidhi company cannot issue preference shares. It was allowed in the old act, but now it is not allowed. They can open the branches if they comply with the rules, like 3 years net profit after tax is required, right? So can they open branches outside the district? No, it requires RBI approval. Along with that, it cannot open branch outside the state because the dealing of Nidhi companies within the state itself. Minimum paid up equity capital required is 5 lakh. It is always a public limited company. Only members loan are given, and they are secured loans. Nidhi company don't provide with the unsecured loans. If anybody wants to become director of a Nidhi company, it is always a member of a Nidhi company. And what is the tenure of such directors? 10 consecutive years the tenure of the directors of the Nidhi company. Can they declare the dividend? The answer is yes, not exceeding 25% with the permission of regional director. Yes, after that there are certain general restrictions. Nidhi company cannot do any business other than lending, borrowing, that too within the members. So they cannot do chit fund, cannot do hire purchase, leasing finance, insurance, acquisition of securities, any other body corporate. They cannot do that. If they want to do, they have to follow the procedure. They cannot issue pref shares, debentures, or any other debt instruments. They only and only can issue equity shares. They cannot open any current account with the members, not allowed. If they want to acquire shares of other body corporate, they have to follow the rules. What are the rules? They require board meeting, in that they will have to pass a board resolution. They require a general meeting, in that they will have to take members approval by special resolution, and last is RD approval. They require regional director approval. Can they carry on any other business apart from lending, borrowing? The answer is no. One exception is there. They can provide for locker facilities. Okay, they can provide locker facility, that to only its members, and out of that the rental income cannot exceed 20% of the gross income. If it exceed 20%, that locker facility provided is invalid. Okay. After that, they cannot accept deposit from any person other than members. Whatever securities are pledged by the members, they cannot pledge that assets further, because those are the assets of the members and not of the Nidhi company. They cannot take deposit from any other body corporate. Can any other body corporate be member of Nidhi company? No, we have discussed that. They cannot issue any advertisement also, because they are only dealing with members. Then what's the point in declaring public we are giving so much of interest? It's not valid. So any Nidhi company gives advertisement, that is not valid. But yes, advertisement given in the private group of individuals who are member, that will not be termed to be an advertisement because it's for private circulation, that is allowed. Then payment of any brokerage or incentive for any broker for mobilizing the funds, it's not allowed, cannot give. Now, what is benefit of incorporating a Nidhi company? Why one should incorporate Nidhi company? Nidhi company helps to mobilize small savings. Basically, the middle class people, the small class of people, they can keep their earnings over there and they can get a good rate of interest in compared to the bank. Also, if they are in need of money, they can take help from the Nidhi company, and there is a less cumbersome procedure in comparison to the bank. Then over here, repayment is mostly guaranteed. Why? Because all the members know each other. So if I default, all other members will be thinking bad about me. So that is the peer pressure, right? So because of peer pressure, the repayment is guaranteed. Defaults are very less. Okay. Then also it offers a higher rate of interest on the deposit. This is what we have discussed. And board of directors of Nidhi company, mostly they are senior person, so they are very experienced, so they do the activities of board very nicely, and affairs of the Nidhi company are carried on very smoothly. Okay, these are the advantages of the Nidhi company. Now going ahead, incorporation of Nidhi company. As I told you, it don't require license of RBI. So what we'll be doing? We'll be incorporating company under Companies Act 2013. Can we incorporate a private limited company? No, it cannot be a private limited company. It has to be a public limited with minimum paid up share capital of 5 lakh rupees. Very important, in object clause, we have to mention that the object of the company is cultivating habit of thrift and saving among its members, receiving deposits from and lending to its members only. This should be the object. If this object is not there, your Nidhi company is not valid company. Okay, then within 1 year of incorporation, these rules are very important. We have to comply with these 4 rules. This we have learned, right? Great. So this was your Nidhi company. So let's start with the last topic of your chapter number 8. I know all of you are so tired about learning about NBFs because this is your new topic, and believe me, it's not that difficult. If you revise it for 2 to 3 times, the fourth time will be a cakewalk for you. Understood? So don't lose the hopes on chapter number 8. This is equally important. So now let's begin with the payment banks. I hope everybody has heard about the payment banks. Airtel payment banks, Paytm payment banks. Okay, so examples. Airtel payment banks we have. Paytm payment banks. Okay, so the examples of your payment bank, and this chapter is about the NBFC, correct? But this payment bank, this topic, see, there is a word called as a bank. Have they used non-bank payment, non-bank? No, they have used bank. So this payment bank, that is your Airtel payment, Paytm payment, they are banks. They are banks, and also they are regulated under Banking Regulation Act. They are regulated under Banking Regulations Act 1949. And who is the regulator? RBI. So till now we have learned the non-banking financial company, but your payment bank is a bank. Now why it has come up? Why? So let's see history of that. Why this payment bank has come up. What is the main or core business of our banks? The core business of our banks is lending and borrowing, right? Lending and borrowing. Apart from that, don't you think bank have to do other kind of things, like it is a part of payment and settlement system? So whenever we have amount in our bank account, we'll just draw the check and bank has to execute that. So lot of time goes into this settlement. Okay, lot of time goes into this settlement. So for solving this problem of the bank, even though they are part of payment and settlement system, to reduce their burden on their activities relating to payment and system, they came across something called as payment banks. So what will be the main function of this payment banks? Are they going to concentrate on lending, borrowing? No. They'll be concentrating on payment and settlement system. What they shall be doing? Payment and settlement system. We have seen, no, if you have amount in the Airtel money, you can pay any of your bills. Yes, you don't need to go to the bank also. Have you seen Airtel payment bank, any of the outlet? Physical outlets are not allowed, complete digital. So your payment bank is totally digital bank. It is totally digital bank. Clear with this? Understood what is a payment bank? Now, our government of India, they came with this payment bank in 2014. So in 2014, they started giving license. They started giving license for payment banks. What kind of license I am talking about? Like NBFCs have to take license from RBI for starting the business of NBFC, right? So the banks also have to take license from RBI to work as a bank. So when payment bank on the same line shall have to take license from RBI for a payment bank. So is there any difference between the bank and the payment bank? Huge difference. Huge difference. Payment bank will be concentrating only on payment and settlement system. It is not going to concentrate on lending and borrowing. So it cannot give loans. It cannot issue credit cards. Okay, we'll be looking into all these parts. So in 2014, they started giving license for the payment banks. After that, there are certain important points we have to learn about the payment banks. Your payment bank is also a company under Companies Act 2013, but it is always a public limited company. It cannot be a private limited company. So it is always a public limited company under Companies Act 2013. Okay, remember, right? Yes. After that, they have to obtain license from RBI. Under which act? Under Banking Regulations Act 1949. I am writing shortcut over here. They are not supposed to write the shortcuts. Okay. After that, it can operate both type of accounts. It can operate both type of accounts. It can operate current accounts also. It can operate your savings accounts also, no problem at all. Along with that, they can also give other services like ATM services. It can give. It can also give the net banking services. It can also give the debit card services. But it cannot give credit card because they cannot lend, right? So, but cannot give loans or cannot issue credit cards. Okay, understood? This is a big difference between the banks and your payment banks. After that, the next point, opening account with this payment bank is very easy. Okay, Opening account is very easy. What you have to do, you have to just follow the steps for verification. Okay, so for opening account, what you need to do, verification, that is your KYC verification, and this is completely done online. No need to submit any of the forms at any of the branches, because payment bank don't have branches. It is totally digital. Clear with this? Understood? Now the next point. Now there is a requirement of minimum capital. It is a bank, so capital requirement is more. Minimum capital requirement is 100 crores. How much capital requirement is there? 100 crores capital requirement is there. So it's a public company. Along with that, it should have a capital of 100 crores. Okay. After that, about the voting rights. We are going to learn something about the voting rights. See, whenever all the voting rights will be as per the Banking Regulation Act. Generally, when it's a company, voting rights are to be followed as per the Companies Act. But for payment banks, voting right has to be followed as per your Banking Regulation Act. Why? Because it's a payment bank, that's why. Okay, which guidelines they have to follow? Banking Regulation Act 1949 they have to follow. And what does it say? Whenever any shareholder is there, it can exercise vote up to 10%. So how much vote they can give? They can give 10% of the votes. Okay, only 10% of voting right can be exercised. Now, if they want to increase, the percentage, what they have to do? They have to take RBI approval. Whose approval they need to take? RBI approval. So if they want to increase the stake beyond 10% and want to vote, so they have to take approval of RBI. But that stake can be increased only up to 26%. Okay, stake cannot go beyond 26% with the RBI approval also. After that, in the same point, if any individual, okay, if any individual wants to acquire more than 5%, how much they want to acquire? More than 5%, compulsorily RBI approval is compulsory. They need to take the RBI approval. Without RBI approval, they cannot acquire more than 5% in the payment banks. Okay, so right now what we have learned, they can exercise vote in the meeting up to 10%. If they want to exercise more, they can take RBI approval and exercise up to 26%, not more than that. Any point of time when they want to acquire stake in the payment banks and exceeding 5%, they have to first take RBI approval. Only after that they can acquire. Now, for first 5 years, okay, for first 5 years, promoter stake, okay, promoters means those who have incorporated the payment bank, promoter stake should be at least of 40%. So how much stake is required? For first 5 years, they cannot disinvest entire stake, but they have to keep at least 40% of stake in the payment banks. Okay. After that, in the payment banks, I told you saving account is there, current account is there. Can you deposit money and keep it in the payment banks? Yes, we do, right? So, your payment banks can keep the funds of the clients or the customers. Like our banks can hold n number of fund, right? But for payment bank there is a cap. So in payment bank we cannot deposit more than 2 lakh rupees. So how much payment bank can hold? Up to 2 lakh. Any point of time it is exceeding 2 lakh, your payment bank is linked to your bank account, right? So that more than 2 lakh rupees, whatever is the extra part, that will be returned to your bank account. Okay, so only 2 lakh rupees we can hold in the payment bank, not more than that. As I told you, this payment bank are specially for those area where there is no bank. They want to make the entire India digitalization, right? So 25% of its operations, RBI wants them to do 25% of its operation in rural areas or semi-urban areas. Rural areas or semi-urban areas where there is no banking facilities. So they want to concentrate more on these areas and they want more and more people to have access of the banks. Okay, now let's go to our notes. What are the extra points? We can see that, as I have mentioned earlier, the minimum capital requirement is 100 crores and for first 5 years, okay, for first 5 years our promoter stake should be 40%. Then if any of the foreigner want to acquire share in our payment bank, can they acquire? The answer is yes, they can acquire, but they will have to follow the FDI rules. This FEMA will be applicable to them. FDI is foreign direct investment. Then we have discussed about the voting rights. Then majority of board of directors of your payment banks will be independent director, and that will be as per your RBI guidelines and RBI regulations. Bank can accept any of the utility bill and it will be fully networked. Can they form the subsidiaries? They can form, but they cannot form subsidiaries for undertaking non-banking activity. They can carry on banking activities, no problem. They cannot carry on the non-banking activities. The deposit cap is, there's a modification, 2 lakh per customer. So how much deposit we can keep? 2 lakh per customer. 25% of its branches should be in the unbanked rural area, we have seen. Very important point. Like in a private or a public limited company, we have to add a suffix, right? Private limited or limited for public. For banks, how do you do it? HDFC Bank, we put it right at, correct? HDFC Bank Limited. For payment banks, how do you write? We will write like this. Airtel Payment Banks Limited. So you have to write this payment banks, then only you can distinguish that this is a bank or a payment bank. If you don't write payment bank for a payment bank, it's a violation of your rules. Understood? So we have to add the suffix payment banks to it. Then it will be licensed by RBI under your Banking Regulations Act 1949 and it will be a public limited company only. With this, students, we have completed your chapter number 8. I hope it was very clear to all of you. As I told you, it is new things for you. So go through the chapter once again and second time you will feel it bit easier. Now let's start with our question answer solving. So first we will see the unsolved one and then we will go to the solved ones. So the first one, Miss Jyoti wishes to form NBFC for carrying on business of providing microfinance in rural areas in name of Faida Loan Company Limited. Okay. Advise her about various categories of NBFC. Let him know as to which category of NBFC will suit him for applying the license. So they have asked you two questions over here. The first question is various categories of NBFC and second one, which category is going to suit. it will be accepting deposit or non-accepting deposit. The main business is providing microfinance to FIDA Loan Company Limited. So which category of loan we have to give? It will be deposit taking, and that is a loan NBFC. I hope this is very clear. Okay. After that, the next one, with reference to ARC, answer the following. First, who regulates ARC? RBI. Functions performed by ARC. The 5-6 points, straightforward answer. What are object of ARC? Simple it is. Then what are restrictions applicable to the Nidhi company? We have to write all the restrictions. It cannot issue preference shares, debentures, all the restrictions it has to be written. Then concept of a self-help group is most exciting discovery in context of microfinance. Explain terms and features of microfinance. The only question is you have to explain term and features of microfinance. When we were learning microfinance NBFC, we have seen what are the features of microfinance. Those things only you have to write. Okay. Apart from that, differentiate between payment banks and the regular banks. We have to write the points of distinction. Payment bank is only dealing with payment and settlement system, whereas regular banks deal with all kinds, giving, taking loans. Regular banks can issue debit card, credit card. Payment banks can issue only debit card, no credit card. Whereas there is limit in your payment banks that we can keep only 2 lakh rupees in the bank account, whereas for the regular bank there is no such limit. Okay, your private, that is regular bank, can be private banks or a public limited, but for your payment bank it has to be a public limited company. So I hope you have understood. These are the basic point of difference between the payments bank and the regular bank. Now going to the solved questions of your past papers, the first one comes as Raghavi and 6 more relatives and friends. They want to incorporate a Nidhi company. Okay. They seek your advice on following issues with formation of the company. First one, whether Nidhi company can be formed as a private limited. Simple answer, no. It has to be a public limited. Is there any specific law for the Nidhi company? No. Only Companies Act, and we have Nidhi Company Rules 2014. Correct? Next one. Whether approval of RBI is required for forming a Nidhi company? The answer is no, it's not required. It is exempted. Whether Nidhi is allowed to raise funds through issue of equity shares and preference shares? For equity shares, yes. For preference shares, no. Because Nidhi company cannot issue preference shares. Whether Nidhi company is allowed to carry on business other than business of borrowing or lending in its own name? Can it do other kinds of business? No, it cannot do other kind of business. Only exception to the rule is the locker facility can be provided only to member, and income cannot be exceeding 20% of its gross income. I hope this is very clear. So simple questions it is, and this was asked in your past papers. So guys, if your concept is very clear, it's very easy to clear. Understood? Yes. After that, next, the definition of net own fund is to be given. So let us understand what is a net own fund. Basically this you will be learning in your accounts part, that's why over here we did not do, but yes, question is there, we will definitely do it. Okay. So as per the rule, what is the definition of net own funds? It is aggregate of, you have to sum it out, paid up capital and free reserves. Okay. So it is like this, paid up share capital plus free reserves. Whatever amount you get, you have to reduce that with the accumulated losses, okay, and intangible asset. This too you have to reduce. Okay, whatever amount you get, further you have to include proceeds of issue of preference shares, Okay, if any amount you have of proceeds of issue of shares, that you have to exclude. So whatever amount you will be getting over here, that amount you have to reduce the amount of preference shares, because in Nidhi company preference share proceeds should not be counted. Okay, yes, so that was your definition. It was very easy. Now going ahead, ARC are created to manage and recover non-performing assets. Comment referring the functions and benefits of ARC. What they have asked, functions, benefits of ARC. Very simple it is. Yes. Apart from that, concept of self-help group is the most exciting discovery in context of microfinance. We have to explain the terms and features of microfinance. This we have also discussed the question. I told you to write these features of microfinance. Okay, also NABARD has given name to this microfinance as for the poor strata people. Okay, so self-help group is very exciting, and the Indian finance scene is dominated by self-help group. What is basically a self-help group, guys? Suppose I have excess of funds, I can lend it. Somebody wants the funds, okay, they are need of capital, so my funds which I have lended, he can borrow it and pay me the interest. Understood? So instead of going to the banks, it's a self-help group. Okay. Yes. Also it leads to empowerment of women, eradication of the poverty. Then microfinance provides greater menu of option where small loan can be garnered not from external but your internal source also. Nidhi company only garners the internal sources fund, but your microfinance from external also and internal also. So microfinance can operate within the members also and outside the members also. I hope you understood. Then biggest flexibility is lack of any physical collateral, right? So bank, it is compulsory to take collateral, but for microfinance it is a advantage. It can give loan without any collateral security. I hope this is very clear to all of you. Great. So that's all guys with your chapter number 8. You will find this chapter little bit lengthy, little bit technical, but believe me, if you read twice or thrice, it would be very easy for you. Thank you so much all of you. Will be meeting in the next video with the new topic, that is chapter number 9. Till then, goodbye.